So this morning we lodged a proceeding with the court, the Supreme Court, in relation to the IBAC's failure to respond to our complaints concerning what we allege is corrupt conduct by the LSBC, by Your Honor, and various LSBC agents, as well as
So when you say you filed
an originating motion and affidavit in support.
when was that done?
This morning.
What time?
It was done while we were driving here. Ms. Xu did it from the car. I think she also
Done electronically.
Electronically, of course. Request. I think she did send an email, our associate said. I was driving, I don't know.
But why are you telling me this? What are you asking me to do?
Your Honor is the defendant in that proceeding.
Okay.
And we say that disqualifies Your Honor. We're not seeking recusal. We're saying Your Honor's disqualified on account of the fact that the law prohibits a judge from acting.
All right. Thank you for informing me, Mr. Kuksal. I think we'll proceed with the cross-examination of Mr. Anstee.
Your Honor, Mr. Anstee, if I may, there are a number of issues with this, and I would just like to address them. Mr. Ben Davidson is a defendant in the proceeding. Mr. McAuliffe is a defendant in the proceeding.
Yes.
The uniform law prevents them from continuing in this matter further. I can cite the rules.
Right? The uniform law?
Yes, the barrister conduct rules, issued pursuant to S-419 of the Uniform Law. So, S-419 of the Uniform Law requires the Law Counsel to formulate the rules.
Yes. I'm familiar in a general sense. What do the rules say?
A barrister cannot act in a matter in which, essentially, there are personal entitlements. I'm paraphrasing.
I don't think that applies to somebody who's halfway through their cross-examination.
It does. It does. I've been in this situation before.
Well, we'll deal with it later. I think I just want to proceed with what Mr. Anstee.
No, but Your Honor, it's Mr. McAuliffe that should be given an opportunity to consider. What I do not well, Your Honor should clarify.
When did you decide that you were going to initiate this proceeding?
Some time ago, and
when did you decide you would tell everybody that the case had to stop because you'd initiated the proceeding?
Your Honor, we've been telling Your Honor that for every day in this matter. The transcript will note.
For this reason, I mean.
Yes. If Your Honor has a copy of the transcript from the 11th of August hearing, or
I do remember you mentioning in the past that you were anticipating
we were imminently lodging
proceedings against IBAC in relation to their failure to,
and Your Honor.
and you mentioned me.
Yes, and we said we were imminently lodging. And we said that it was delayed because I was ill.
All right.
The lodgment was delayed.
Okay. Anyway, so you're saying that who can't continue, obviously.
None of these parties can continue.
So this case has to stop until when?
So, Your Honor,
Can Mr. Anstee give evidence?
does Your Honor have a copy of the originating motion?
No. Of course not.
It was sent this morning, under the impression. It sets out the sections we're relying on.
I think I've got the rules here, somewhere. My associate tells me that the registry says that they don't have any record of it being submitted for filing. So it might be lost in the computer system at the moment.
Well, it's...
Yes. It might be too new that it hasn't worked its way through.
But can Your Honor confirm if the court has received a copy of the...
Well, I haven't. When you say the court,
Your Honor's associate is what I mean.
no.
Okay, well they should have sent the e-copy. Okay, I'll just tell Your Honor what the section is.
I've got the legal profession uniform general rules in front of me. Is that what you're referring to?
The barristers' conduct rules.
Barristers, conduct rules, I don't have it. So that applies only to Mr. McAuliffe.
Yes, and then the solicitors' conduct rules that apply to solicitors.
Yes.
They also prevent a solicitor from acting in a matter in which they have a personal involvement.
All right.
Now, Your Honor,
That's not this matter.
this matter, we're saying that they've committed. So we made a series of complaints about the LSBC to the IBAC.
Yes.
One of those complaints is that they have conspired or they have effectively, improperly exploited the
Yes. All right.
assistance they're getting from you in this proceeding to improperly deny us.
So, is Mr. McAuliffe a defendant to the proceeding you've initiated this morning?
Yes, because Mr. McAuliffe is personally acting.
Well, I can say I'm not troubled myself. I'm not going to recuse myself because you've issued a proceeding this morning in which I'm a defendant. I'm going to stand the matter down for a couple of minutes just so Mr. McAuliffe, I think I have to give him the opportunity to reflect on his own.
I also wish to identify that we're relying on S50 of the Public Interest Disclosures Act, in stating that the court should injunct Your Honor from proceeding in this matter.
You don't have to tell me that, Mr. Kuksal. If the Court of Appeal stops me from acting, I'll cease acting.
But, Your Honor, I am entitled to make a submission to Your Honor.
Mr. Kuksal,
The submission is that if Your Honor,
I asked you, you say you're not making a recusal application. You're just telling me stuff.
No, there's a difference between seeking a recusal on the...
But you don't want me to make any...
No, I want you to recuse yourself, of course.
But you're not asking that I make any orders.
Of course, I'm asking that Your Honor recuse. I'm saying that Your Honor has to recuse himself.
Alright, well, I've made a direction that any recusal application be made in writing by midday tomorrow.
Your Honor, that couldn't apply for...
That applies to this recusal application as well.
Okay, Your Honor, there is a section in the Public Interest Disclosures Act that entitles parties that are concerned about being subject to reprisals and gives them the entitlement under the Public Interest Disclosures Act to be heard by the Supreme Court in respect to that matter. You will be rendering that application nugatory.
Well, I'm not going to. I have not made the order yet. I'm just going to proceed.
No, but there's a detrimental action to which we're exposed in these matters proceeding.
Alright.
In things being said in court,
Mr. Kuksal, I'm not going to stop this trial. I'm going to stand this matter down for 5 minutes so Mr. McAuliffe can have an opportunity to tell me what he thinks.
We will not continue before you give reasons. We will not continue.
If Mr. McAuliffe tells me he feels the need to do something or other, I'll listen to what he says. If he says he's ready to push on, we'll push on. And we'll hear Mr. Anstee. Have you got more cross-examination of Mr. Anstee to be done?
Yes. But I would like Your Honor to give reasons before...
Please.
I'm not going to continue before Your Honor gives the reasons.
Well, mister.
I'm not.
I made my ruling yesterday about...
Yes, but that was before this proceeding was lodged. It cannot apply.
No, we're at cross purposes. I'm talking about Mr. Anstee at the moment. I gave a ruling yesterday afternoon that questions directed at his reliability were, in my view, not proper. Do you have cross-examination that goes to issues other than that?
Okay. Firstly, Your Honor, we should not be addressing this matter because of the issue.
Of course.
And I reserve my right in respect of that. Secondly, that is not what Your Honor said yesterday. What Your Honor said is that I had failed to identify a relevant matter, and therefore, Your Honor was ruling. Now I disagree that I had failed, but I will attempt to identify more basis upon which credibility will be relevant to press on.
No, I'm afraid
Well, I'm not gonna...
Mr. Kuksal, I am asking you a question. I've made a ruling.
Yes. You made an interlocutory determination.
I have made a ruling that...
I will re-agitate that matter.
That it's not an opportunity for an investigation, that the motive be clear on the Legal Services Board, and that you're not to be permitted to ask questions directed at establishing that Mr. Anstee is an unreliable witness. That is my ruling.
Yep.
That continues to apply.
Your Honor,
Now, do you have any questions of Mr. Anstee that are...
I will...
Other than on that point?
You made that ruling on the basis of...
I made that ruling, Mr. Kuksal. Are you able to answer my question?
Your Honor, you're not letting me speak.
Do you...
You're doing what you always do.
I'm asking you to...
You try to suppress the record.
I am asking you a question.
Yes.
Do you have questions of Mr. Anstee that are not directed at establishing that he is an unreliable witness?
Okay. I will answer that question, and I will request that Your Honor not interrupt me.
Well, I want you to start the answer with a yes or a no, and then explain.
I cannot do that. I can't do that.
You can't say that you have questions.
I will not.
Other than on that.
I will not be answering questions in a templatized manner that Your Honor dictates to me. That is incompatible with my rights.
Mr. Kuksal, I am going to stand the matter down for a few minutes, as I said to Mr. McAuliffe, so Mr. McAuliffe can reflect on what you have said, because I think it's fair that he have the opportunity to do so. I want to make it absolutely clear to you that if you continue to ask questions that I consider are improper, having regard to my ruling, I will treat that by you as an abandonment of your right to cross-examine, and I will bring your cross-examination to an end.
Yeah.
And you can?
You'll do what you will do.
Complain about it, or appeal me, or whatever. But I want you...
That's why I'm weak.
I want you to understand that if you do not ask questions on topics other than that, I will treat your cross-examination as having...
Okay.
Been ended.
Your Honor. Yesterday.
I'm telling you that...
But yes, but let...
So you know.
Me just... Pardon?
Do you understand?
Yesterday.
Do you understand?
I'm answering that question. Yesterday, Your Honor repeatedly sought to stop me from addressing the court about a matter. I did not cooperate. Ultimately, when I did address the court about the matter that I want to press, the court accepted that it was consideration worthy.
I don't accept that, Mr. Kuksal.
Well,
I'm going to stand the matter down.
If Your Honor has copy of the transcript.
I'm going to stand the matter down for 5 minutes. I can clarify that mine, not my, but inquiries made with the registry confirm that the document has been received by them but has not yet been accepted for filing, so that's the status of it.
That's irrelevant, Your Honor, because
I am just letting you know I think they received it, I'm told, at the same time that we all did by email sometime after 11.
I think it was because of the internet connectivity, but Your Honor,
That as it may, that's the situation, yes.
sure, I simply wish to cite a rule which says that if the Prothonotary improperly delays the or withholds the acceptance of a document, then the matter can be raised directly with a judge. We put the Prothonotary on notice of our intention to exercise that right, given that the Prothonotary—
Well, I think the Prothonotary decides, and then you've got the right to have that reviewed by a judge.
Yes, but if they don't do it soon enough, then that's a decision.
Yes.
And the Prothonotary is a defendant in the proceeding because they have previously withheld the acceptance of the 4028 originating motion until after the 3994 motion was lodged.
How many defendants are there?
I believe 27.
Okay.
But it's essentially the LSBC
Okay.
and the agents of the LSBC,
Me, Mr. McAuliffe, and the Prothonotary, and the VLSB and IBAC.
IBAC, and the Victorian Inspectorate.
Yes.
Because we made a complaint against the IBAC to the Victorian Inspectorate.
All right. Well, I stood it down, so Mr. McAuliffe, I might just ask Mr. McAuliffe.
May I just say one thing before that?
No, just wait. You can't. I'll come back to you.
Because he has to address that.
You keep saying people have to do things. Mr. McAuliffe, do you feel comfortable proceeding if I'm prepared to proceed?
I would seek time to be able to seek an ethics ruling on the issue and then be able to revert to the court on that.
What sort of time frame are you thinking of there?
Potentially, having already given an indication that a ruling might be sought, potentially in the next 10 to 15 minutes.
So should I stand it down until midday, say, so you can do that?
I would be grateful if possible.
Can you, Mr. Kuksal's got a couple of things he wants to say. Can you seek an ethics ruling whilst he's saying those, or do I?
No, I seek an ethics ruling while that's happening, Your Honor.
All right. So I won't recommence the merits of the matter until I have spoken to you again, Mr. McAuliffe. Yes, Mr. Kuksal.
Your Honor.
Let me clarify. You're in the process of seeking an ethics ruling at the moment?
Yes, that's so.
All right. Thanks.
Your Honor, Rule 101 of the Barrister Conduct Rules says that 101, brief which must be refused or must be returned. A barrister must refuse to accept or retain a brief or instructions to appear before a court if, and then it lists approximately 14 to 15 scenarios. If I may just—
But why are you telling me? I'm not interested. It is for Mr. McAuliffe.
No, Your Honor, because I simply want this to be noted. One of the criteria is if the barrister's conduct is attacked in the proceeding. Another criterion is if they are a witness. Another criterion is if they are personally the subject of orders, thereupon all their interests are affected. If Mr. McAuliffe continues, he would be effectively doing it on the basis that our allegations in the proceeding are baseless and frivolous, and we're not genuinely attacking, or we have no basis to make a complaint against him in relation to his conduct.
Yes.
We will treat that as further detrimental action. That will be the basis of further complaints. The same applies to Mr. Davidson, who will be cross-examined. Mr. Anstee should have been outside for this matter. He's a defendant too.
If you want him outside, then just ask him to step outside.
No, I don't see why Mr. Anstee has to be outside whilst Mr. Kuksal is telling me this. If you've got this is open court. He's being cross-examined. I've said, his credit isn't going to be cross-examined on his credit. He's producing documents. Why does he have to be outside?
Well, you've said that on the basis of facts that existed yesterday. I will.
It is my ruling.
Yes, and I will.
I am not going to
make a fresh application.
I am not going to revisit it.
Your Honor, you cannot.
I am not going to revisit.
Stop me from making.
I can stop you.
No, you cannot stop me from making applications. You can rule against me. Those are two different things.
I can stop you from making applications, Mr. Kuksal, if I think you are making the same application repeatedly for—
But I'm not making—
no proper purpose.
The same application repeatedly.
I am telling you.
Okay. Your Honor, I will not—
That I am—
accept what Your Honor is saying.
Well, you don't have to accept. I'm telling you that.
In the sense that I will not—
I have made my ruling. I am not going to permit you to cross-examine Mr. Anstee on his credit in this proceeding.
Again, if Your Honor is threatening me with contempt, then I will just not continue. But I'm not going to not re-agitate the matter. I'm being very transparent about it.
Well, I'm telling you, if you do not ask questions,
That's a threat, Your Honor. That's an improper threat.
No, just...
You're threatening me to...
No, you haven't even heard me.
You're trying to silence me. I'm saying, I will wish to raise a fresh matter.
You haven't even heard from me. What I'm saying is that, if we recommence the cross-examination of Mr. Anstee, and you, instead of asking that I consider a proper questions to ask, you persist in seeking to either ask questions directed at his credit, or persist in challenging my ruling, or asking me to change my ruling, I will treat that as a constructive decision by you not to proceed with your cross-examination, and I will bring your cross-examination to an end.
I consider that to be detrimental action. I consider that to...
Fair enough.
Be an improper threat, and I will not cooperate with it.
Well, I'm telling you what will happen, and do it.
And that's fine. You don't have to repeat yourself. It will not change things. You've said that repeatedly.
All right.
Which, again, is further intimidation tactics.
I want to make sure that you understand that, so that, if that happens, you don't say that you weren't given notice.
I think, Your Honor, we've both made ourselves very clear.
Thank you. All right. So you say the barrister conduct rules are engaged, and that's a matter for Mr. McAuliffe to...
And the solicitor conduct rules. But it's also a matter for the court, because the court has an inherent duty, and not right, but duty especially, when there are self-represented parties at the other end, to ensure that barristers and solicitors are complying with the rules of the court. Or the profession.
Profession, all right, yes.
So if you overlook a deliberate breach of the rules, Your Honor, this ostensibly gives the impression that the court simply wants to further an agenda. The matters that are alleged in the IBAC proceeding are far more serious than the matters that this proceeding seeks to. I don't even know what the matters are, but in any event, there is no public interest, there is no urgency. Your Honor hasn't identified one. The plaintiff hasn't. What Your Honor has said, that proceedings should be generally conducted quickly. Your Honor also hasn't ruled that we're deliberately trying to improperly impede the progress of proceedings by raising matters that are calculated to pervert the course of justice. In those circumstances, what Your Honor is, I don't know whether Your Honor could still do what Your Honor is doing, but there would definitely be consequences for us. But you haven't made that finding of fact. You are simply refusing to follow the law.
All right, Mr. Kuksal.
If you're perverting the course of...
I feel like you're just talking to me with no end purpose.
Well, I feel like that all the time, Your Honor.
Yes, okay. But this case...
When you repeat the...
This case at the moment, in this case we're in the process of extracting the evidence that is going to be used.
You say that there is a case. We're alleging that we're being held hostage.
Okay.
By a judge who is acting corruptly.
But you just keep...
In collusion with the other side.
But Mr. Kuksal, you keep telling me that. You're not...
And you're
not going to...
Telling me something else.
You're not going to persuade me of that. So,
Your Honor,
So, my inclination is that I am going to proceed with this matter. If Mr. McAuliffe doesn't want to proceed, that's one issue I will have to deal with. Otherwise I am...
And Mr. Davidson?
Otherwise.
And Mr. Davidson. He's the solicitor.
Mr. Kuksal.
Your Honor,
From my own point of view, I'm going to proceed. And if you say that I have to stop, you're going to have to get an order from the Court of Appeal stopping me.
Your Honor.
There's no point just talking to me and telling me all the things I'm doing wrong.
There is, because
Well, there's not.
The allegations that we're making against Your Honor.
I'm going to adjourn the matter now, till I've told you my position. I will adjourn the matter.
Yeah.
Till 12 o'clock, by which time I hope that Mr. McAuliffe will have had an ethics ruling, or a position, and Mr. Davidson needs to consider his position, I suppose. As your concern is not, Mr. Kuksal, his position as a person who swore an affidavit, but his position as a solicitor, with the conduct of the matter.
With the conduct of the matter.
Well, he will have to reflect on that too. But I take that to be a matter for them. I will stand the matter down till midday. Mr. Kuksal.
Yes, Your Honor. Firstly, I wish to make an application for Your Honor's recusal, on the basis of the lodgment of the proceeding.
Mr. Kuksal, I repeat my order that any application for my recusal be made in writing by midday tomorrow. So you do that, and I will deal with it in due course.
Okay. Then I make
I am not going to delay the trial in the meantime.
Sorry, Your Honor, I'm entitled to make applications, and I will make them.
I'm telling you when you can make that application, and how you can make it. You can make it by writing.
Your Honor, this is delaying matters further.
Filed by tomorrow midday.
If I may just simply say what I'm saying.
This is your opportunity to cross-examine Mr. Anstee. If you don't...
Yes, and nothing that I'm...
Mr. Kuksal.
Doing is improper.
You are not cross-examining Mr. Anstee. If you...
That's not true. I'm secure.
Mr. Kuksal. I'm sorry. If you don't start cross-examining Mr. Anstee now, and asking appropriate questions, I will treat you as having ceased your cross-examination.
That would be improper. Because
That's what I'm gonna do.
Your Honor, please, you cannot shut me up.
Mr. Kuksal.
No, you.
I can.
Please, what you do is you say stuff, and then you don't let me respond, and you say the things that you say are about what you understand my intentions to be. I'm entitled to express my own intentions.
You are now obliged to either cross-examine Mr. Anstee or not.
Okay.
Cross-examine Mr. Anstee.
I am also obliged, by law, to raise some matters with you.
No,
Yes, I am.
This is.
Your Honor.
I am not permitting.
Yes, I am.
I am not permitting you to do anything at the moment, except either complete or not complete your cross-examination of Mr. Anstee.
Yes, and I wish to simply point out that before Your Honor had adjourned, Your Honor had stated, in court, and it will be part of the transcript, that Your Honor will need to consider the appropriateness of Mr. McAuliffe and Mr. Davidson in continuing this, as after I had raised the point about the rules.
Mr. Kuksal, I am not going to stop Mr. McAuliffe or his instructor from proceeding in the matter.
I allege that this is
your last opportunity to finish your cross-examination.
Your Honor, I'm simply
of Mr. Anstee.
I'm not going to take long, I'm just
No,
I'm going to say this for the
Mr.
sake of the record.
This is your opportunity.
Because I'm obliged to. Your Honor, you're not changing the law.
You either cross-examine Mr. Anstee or you leave the court and we proceed.
Your Honor, I'm not going to leave.
With a re-examination.
I'm not going to voluntarily leave the court, and I'm not saying I'm not cross-examining him.
No. This is your.
I would have been done by now.
This is your opportunity.
Yes, and I am exercising my opportunity.
To cross-examine Mr. Anstee. This is your last chance, Mr. Kuksal.
Your Honor, no. This is an improper threat, Your Honor.
It
is an improper threat. I would have been done by now. I am simply saying that Your Honor is now a defendant in a proceeding. Your Honor had previously made representations that when that happens, the matter will be different, and the matter will need to be considered. Those representations were made repeatedly, as late as
Mr. Kuksal.
Earlier this month. Your Honor, please. I'm not going to take too long. I'm just simply stating that for the record. Now that that has happened, it is, in our submission, incumbent upon the court, in line with its previous representations, that it consider the matter for what it's worth, and it is our position that Your Honor continuing with the matter will render the so. What we're seeking is an opportunity for the other court to stop you, Your Honor, from acting any further in this matter. What Your Honor is doing is necessarily rendering that opportunity, that application, nugatory. I refer the court to authorities which state that that is improper, and it reveals prejudgment. The threshold that we have to meet right now is reasonable apprehension of bias. Your Honor is also doing.
Mr. Kuksal.
Your Honor.
I have let you talk for a bit. You are continuing to make an application that I have told you I am not prepared to hear at the moment.
And I'm saying that.
An application for you disagree. I accept that you disagree. Do not talk over me. If you want to apply for an order that I recuse myself, you put something in writing by midday tomorrow. If you want to get an order from the Court of Appeal to stop me hearing this matter, you can do so. At the moment, the only thing you are permitted to do in this courtroom is to continue with your cross-examination of Mr. Anstee. If you do not do that now, I will treat you as having abandoned or waived your right to cross-examine him, and I will proceed with the Anstee.
That would be unlawful.
I will proceed.
That is not what is happening here.
That is what I am going to do.
Well.
And I will proceed with the re-examination.
Your Honor, you can.
With Mr. McAuliffe.
Break the law, but that is not what is happening here.
Are you?
No, Your Honor.
Will you?
Will
you now commence with your cross-examination?
Your Honor,
of Mr. Anstee?
The prejudice that I face is that the law being what it is, I am obliged to raise matters that I know to.
Mr. Kuksal, you have raised enough. You have put.
Can.
You?
No, but there's.
No, Mr. Kuksal.
There's another matter.
Mr. Kuksal.
They're matters that I've not raised, which.
I am going to adjourn the court for 5 minutes. I would ask that Mr. Kuksal be removed from the court and placed in a room where he can have access to listen. Mr. Kuksal, I treat.
Sorry, are you ordering me?
I am ordering you out of court.
That's imprisonment.
And.
I don't want to be in that room.
I am excluding you from the court.
Okay. But.
In circumstances where you will be given access to.
But am I.
Watch the court proceeding.
Am I being forced to be in the room?
No,
Okay.
You.
I am not going to be in the room.
Mr. Kuksal, listen. Stop.
Yes.
I have decided that you have elected not to continue with the cross-examination of Mr. Anstee. I am removing you from the room so that Mr. McAuliffe can re-examine, because you are refusing to accept
That is not the case.
my direction to sit down.
That is not the case.
If you want to observe the re-examination, the facility will be made available
That is not the case.
for you to do so.
I wish to immediately access my rights to raise complaints against Your Honor
You can do that.
with appropriate agencies.
I understand.
So after you remove me? Yes, I'll do that, thank you.
Mr. Kuksal, do you want to be given a couple of minutes so you can set yourself up in the room to re-observe the examination?
Your Honor, you are removing me from the court.
Yes.
I'm not going to be.
I'm offering
No, I wasn't heard about the prejudice.
you a couple of minutes.
No.
Do you want me to stand the matter down so you can set yourself up in the room?
No, I'm not going to be. You have not given any reasons.
Mr. Kuksal, do you want me to stand the matter down?
Your Honor, you have not given any reasons
If you want,
or steps that you're taking. You have not heard me. It's against the Evidence Act. The Evidence Act provisions set out the circumstances in which the court may make an order for remote witnessing, remote examination.
Mr. Kuksal,
You have not complied with any of those requirements.
will you voluntarily leave the courtroom?
I'm not voluntarily leaving the court.
Will you please remove Mr. Kuksal?
Okay. That's fine.
I'll ask you again, Mr. Kuksal, do you?
No, Your Honor, please. You're baiting me. What you are doing is extremely improper and indecent.
I am not.
Please don't talk to me. You have removed me. Please don't heckle me.
All right. In the absence.
No, please don't. Please don't talk to me. You're antagonizing me. You're deliberately doing this. You have removed me. I am no longer in court. I am simply picking up my stuff and leaving.
All right. You have the opportunity.
Your Honor, I don't want. Please do not address me.
I am going to finish saying.
You have removed me from the court.
I'm going to finish saying this.
Okay, then I will say this in response. I should be given an opportunity.
If you asked
This is still a free country.
If you asked me to have 2 or 3 minutes adjournment, so that you can set yourself up into a room,
No, I want to be heard about.
to observe, I will do so.
I want to be heard about the provisions of the Evidence Act.
If you do not ask me for that, then we will stand the matter down and we will proceed with Mr. McAuliffe.
Okay. I want to be heard about the provisions of the Evidence Act.
Please have Mr. Kuksal removed from the courtroom.
Can I get a couple of minutes, adjournment, so I can speak with her about where the car is parked?
I didn't hear that.
I'm requesting that the court adjourn for a couple of minutes, so I may inquire with Mrs. Hu about where the car is parked. She parked it.
You can just ask her now. Thank you. For the avoidance of doubt, Mr. Kuksal, I am not preventing you from returning to the room.
Your Honor, I was not heard about.
I am not returning you to.
No, you removed me from court.
I am not preventing for the next witness.
You're gagging me. I'm not going to.
I have removed you from the court so that the re-examination of this witness can proceed.
No, this is not a proceeding. This is a travesty of the court process.
Mr. McAuliffe.
Yes, Your Honor. I indicated at the start of today that I would seek 5 minutes, just to be able to confer and take instructions about a very, very short matter before commencing re-examination. It would assist.
I'll give you a minute. Stand the matter down for a minute. We'll have to warn Mr. Anstee again.
Mr. Anstee, you were asked some questions in relation to a Mr. Nailon and his reports. Do you remember those questions?
Yes.
Do you know, or can you tell His Honor, about Mr. Nailon's experience for the board in conducting audits and investigations?
In broad terms, I can say that Mr. Nailon has been conducting compliance audits in that particular role for a good few years. I'm not exactly how many years. And that he's undertaken a fair number of compliance audits on behalf of the board.
And so in producing those reports by Mr. Nailon, as terms of document production for your affidavit, you had knowledge about Mr. Nailon's experience in conducting these audits and investigations for the board?
Yes.
Now I'll show you this document, please.
Is this in the...
Pardon, Your Honor.
Is this in that affidavit?
It is in an affidavit. It was in an affidavit, sworn by Mr. Nailon in 2022.
But not in the affidavits before me at the moment?
No, but it's a document that's signed by Mr. Anstee.
Show it to Ms. Shu, and indistinct. Any objection, Mr. Ansel, Or Miss Shu?
No, Your Honor. I'm just reading the document for the minute.
What's it go into, this re-examination, Mr. McAuliffe?
There are 3 documents that I seek Mr. Anstee to look at. This document, further correspondence that he sent on the 10th of May, and then a separate correspondence on the 3rd of October.
What's the issue that it goes to?
Goes to the issues raised by Ms. Shu in her cross-examination about her risks of committing or non-compliance with the uniform law, absent an injunction.
All right.
Mr. Anstee, do you recognize that document?
I don't recall this document, but I do recognize it's my signature on the document.
And this is a document dated the 3rd of May 2022, addressed to Ms. De Gregorio and Ms. Shu.
Yes.
And is that your signature there at the bottom of the document?
Yes, it is.
Thank you. I tender that document, Your Honor.
Have you got a copy for me?
Yes, Your Honor.
And my associates will need one as well. Thanks.
Now, Mr. Anstee, reading from this letter. This is a letter under your hand to Miss De Gregorio and Mr. Shu, confirming the appointment of Mr. Nalon.
Yes.
And the provision of Mr. Nalon's reports to Ms. Shu.
Yes.
In the second last paragraph, it refers to a management systems direction. Do you see that?
Yes.
I will just seek that the witness be shown another document. I will just provide 3 copies to Your Honor's associate, Mr. Anstee, turning to the second page of that document. Is that a letter dated the 10th of May 2022 under your hand?
Yes.
And is that your signature there on the document?
Yes.
And is that addressed to Ms. De Gregorio and Ms. Shu?
Yes.
And that's enclosing a management systems direction issued for People Shop, Pty Limited?
Yes. That's correct.
And just turning to the front page, is that an email that's forwarded that letter and the direction through to those persons?
Yes.
I tender that document, Your Honor. If the court pleases, I will show you another document, Mr. Anstee, and there's 3 copies I'll hand to Your Honor's associate. Mr. Anstee, do you recognize this document as being held as part of the files by Victorian Legal Services Board in relation to People Shop and Erudite Legal? Yes. I don't recall seeing this document, but it would be held on our files.
Can I object?
Yes, Mr. McAuliffe. So you're showing to Mr. Anstee an email from Mr. Rapke?
Yes.
To people at Erudite Legal. Not obviously copied to Mr. Anstee. Not authored by Mr. Anstee.
That's so.
How is it admissible, and how will you use it?
Well, it's admissible firstly. Your Honor can review it under S57, so S55, 57, provisional relevance, so we can make an inquiry into it. Second, there's no issues in terms of, I might just work through that to answer Your Honor's questions slowly.
Can I ask this? What's the point in, if it's admissible, having it tendered through this witness?
The point is there in the first paragraph and the second paragraph in relation to what is said to those persons, and Ms. Ku. That is despite being in receipt of the audit, the knowledge of Mr. Nalon, the reports from Mr. Nalon, and those matters put by Mr. Rapke, there are still use of Erudite Legal livery and representations that they have had day-to-day management.
So you're relying on this. You want me to accept the truth of the representation made by Mr. Rapke?
That's so, yes.
In this letter, despite Mr. Rapke not being available for cross-examination, this letter not being produced to the defendants in advance of the hearing, and Mr. Anstee not even recognizing the email as something he's involved in?
It was produced to the defendants. It was produced in Mr. Davidson's original affidavits in 2022.
Yes, okay. They've got it.
Yes.
But in terms of them knowing what material they're facing in this application...
No, I accept that. But this is a matter that arose in cross-examination by Ms. Chu, in relation to questions that were put to Mr. Anstee about risks. She asked him particularly about he was not aware of any future risks in the breach of the uniform law.
Yes.
And he was not comfortable. His answer in essence was he was not comfortable answering in detail. But there's other evidence in relation to the conduct and risks available in other evidence.
Say that again.
Trying to paraphrase.
I can look at the transcript. I will have the transcript.
Yes, in essence Mr. Anstee's response was he pointed to there being other evidence available as to that risk. Now,
I am not going to allow it, Mr. McAuliffe. It seems this is my provisional thinking, and I will give you a chance to deal with it.
Yes.
It's just unfair. Ms. Chu, very properly, start with the proposition that Mr. Anstee's evidence, Mr. Anstee's been called to produce documents.
Yes.
Over all that, his credit's not an issue. Ms. Chu has extracted from cross-examination in substance from him, and he's not aware of anything beyond the documents
That he's produced.
that have been produced that suggest that she's a risk. And now in re-examination, you're trying to get in a representation to the contrary Mr. Rapke made.
Yes, indeed. Because,
In October 2022,
yes, it arises from cross-examination. Mr. Anstee's answer specifically referred to what he had produced, but acknowledged that there was other material that had been produced in this proceeding.
yes, well, I don't see that as, I see this as further evidence in chief material then, if that's going to be led in that way.
But I didn't lead it in evidence in chief, it was
I understand that.
specifically asked in cross-examination about future risk, and this here, in my submission, demonstrates that what was put against Ms. Chu in this email is continued use of erudite legal livery and representations about the management having receipt built.
Suppose Mr. Rapke's not telling the truth here, or he's got it wrong. How does Ms. Chu deal with this?
Well, she can give evidence about that if she needs.
No, she can't because she hasn't put an affidavit in.
Well, then it is.
Then why would she put an affidavit in when she didn't think dealing with this document, if this document's not part of the case that was marshaled against her for the proceeding?
I accept that it wasn't part of the affidavits that were prepared in advance for this hearing.
Yes.
We, of course, I and my instructor had no knowledge of the questions or what was going to be put on behalf of any of the defendants, including Ms. C. The question's been asked about her future risk, and I say that this is clearly relevant as to that risk because it demonstrates that absent some form of court order, and I concede, of course, that there has been compliance with interim injunction. But despite having knowledge of the audit, Nalon's reports, there are still on the face of this document, and I accept that the court would have to accept what Mr. Rapke said in this email as true. Continued use by Ms. Chu, amongst others, of erudite legal livery and representation.
How do you get over the simple objection of it being hearsay? You say it's a business record. Anstee she said?
Yes, it's a business record. Again, this is what is occurring here, and is clearly, firstly, management directions that are in place, the appointment of Mr. Rapke, which is in evidence, and business records. And the point that is made, particularly once something is admitted, either through a hearsay exception, the business records or otherwise, S60, for example, is that once it's admitted, it can be used for any other purpose. So I do say,
why is it a business record? Just section
69.
69, I'm just bringing that up. So this is a document that forms part of the records belonging to or kept by a body or organization. So which is the body or organization that's keeping it, in your submission?
Holding Redlich.
Holding Redlich, and so it's a representation made by someone in the course of that business.
And if it's not Rapke, of course it would be the board has kept, as part of Rapke's appointment.
Can I short-circuit it this way, Mr. McAuliffe? It may be a business record and strictly admissible on that basis. It doesn't immediately leap out to me that an email like this is a, putting that to one side, why wouldn't I make a direction in accordance with 136 of the Act, that this evidence can't be used as the truth of what it asserts, on the basis that it would just be unfairly prejudicial to the defendants for it to be relied on in that way?
I don't mean to be clever in my answer, Your Honor, but Your Honor can certainly make that direction, and I would accept that. But that's as to the use of it being for its purpose. But it of course could be used to negative any submission that would be made, or the cross-examination from Ms. Chu, as to the risks, future risks. So I'm not relying on it as the truth of its purpose, that it is saying Ms. Chu has continued to use erudite livery, or engage in day-to-day management, but using it as to indicative of the future risk of Ms. Chu.
But how does it go to the future risk, unless it's established that it was true at the time it was said on the 3rd of October 2022? So the only way it could be used to go to a future risk is if I were to conclude that on the 3rd of October 2022, Mr. Kuksal and Ms. Chu were continuing to use erudite legal livery, and that Mr. Rapke had drawn it to their attention, asking them not to do so.
I wouldn't agree with that pathway of approach, Your Honor. I would say that, accepting, and of course, I would rely on S71 of the Evidence Act in terms of hearsay, not applying to representations in a document. About two things were particularly emails, electronic communication, as to the identity of who documents were sent to, the dates of the destinations, So Your Honor is of course accepting this document as who it was sent to, and who it was sent from, and the dates and time and such matters. And then the appropriate pathway is, it is certainly relevant, and then secondly, in dealing with hearsay exceptions. And so Your Honor I say, it is admissible under firstly, S60, because it goes to meeting the cross-examination in relation to the future risk, and it particularly is relevant in the context of those two documents that I've just tendered through Mr. Anstee first, being the confirmation, a provision of information to Ms. Koo about the appointment of Mr. Naylon and the order reports, and then the practice management direction. And, of course, Your Honor already has evidence from Mr. Anstee's affidavit about Mr. Rapke's appointment and the termination when that occurred. So, it's admissible under S60, and then once it is, a case such as Schultz v. the Queen very clearly indicates, once admissible, it can be used for.
Yes, I understand.
Yes.
What I'm going to do is I'm going to admit it, subject to argument as later argument. Give me a sec, Ms. Tsu, but I'm going to indicate to you, Mr. McAuliffe, that I'm doing this, in a sense pragmatically. My current intention, unless you can persuade me to the contrary, is to direct myself in accordance with either 135 or 136 of the Evidence Act, that I'm not to use any assertions made in this document against the defendants, because it would be unfair for me to do so, in light of the hearsay nature, and the way in which it's emerged in the re-examination of a witness. This witness's only role has been to produce documents. This document could have been produced at any time. It's produced in re-examination. It's not really a clarification of the answers in cross-examination. It's a further development of the argument you want to put. In a sense,
well, the arguments weren't put in relation to and in the submissions about the future risk. That's something that arose from Ms. Shu in her cross-examination, and I've sought to clarify now that as an issue.
But the evidence has been that Mr. Anstee is not aware of anything that shows as an additional risk. What was the page of the transcript?
Apologies, I don't have that reference in front of me. Here she was say.
Whilst Mr. McAuliffe is just finding that reference, Ms. Shu, what did you want to say?
First of all, I want to ask Ms. Anstee if, through the court, that if he wants to make any comments or agrees to tender this as part of his evidence, he might not want to, first of all, and…
Mr. Anstee?
Yeah.
No, but Mr. Anstee has identified the document, and now Mr. McAuliffe is trying to tender it.
Okay, all right. Again, this is an email that's being sent by, again, Mr. Rapke and I do not think that Mr. Anstee will have any comments on this. I see no utility for Mr. Anstee, through Mr. Anstee's cross-examination, to have this document tendered. And again, I will have to check if we have responded to this email or not. I highly doubt that we didn't respond to this.
Thanks.
It didn't mean, when Mr. McAuliffe says the best business record, and, is like, there's no dispute. I highly doubt it, but I will have to check.
Yes. I understand what you'd be saying in substance. You're not in a position to respond to the suggestions.
Yep.
Mr. McAuliffe, were you then going to ask Mr. Anstee any questions beyond identifying this document and tendering it?
Apologies, Your Honor. I'm just trying to find that reference.
Well, put it this way. Were you going to ask him a question, invite him to give evidence that I'll have to either decide to accept or not to accept, basing on an assumption I make about whether he's a reliable witness or not? And if you're going to do that, how does that affect my ruling that this is not a witness whose reliability is in issue?
I'm not going to ask him a question that it goes to his Mr. Anstee's reliability or credibility. Questions that flow from this is then a question that I would ask in re-examination about his, as Ms. Shu asked him, about his opinion of, evidence about her future risk.
What question would you ask?
Well,
when you say evidence about, are you asking for his opinion on her future risk?
Yes, because that's what
I'm not going to allow that.
Well, then I won't ask that then, Your Honor.
Yes. To me, the reason for that is, if you were going to be relying on Mr. Anstee to give opinion evidence of Ms. So's risk, it should have been in an affidavit. I accept your point that Ms. Shu raised the point, but really, all she got from Mr. Anstee was that he wasn't aware of any facts beyond those in the affidavits. I have made a ruling that I have enforced that Mr. Anstee is not to be cross-examined on his credit, and I think if you in re-examination are given leave to extract opinions from him, it undermines the way in which the matter is being conducted.
No, I accept that, Your Honor. And I certainly wasn't seeking to undermine Your Honor's ruling in any way.
I didn't mean to suggest that was your intention.
No. The issue is, really, the approach was, in Mr. Anstee's evidence, I was just trying to find the transcript.
What was the page that…
Yes, if I can just, page 290 onto 291. So the question is asked by Ms. Shu. Okay, may I have 1 minute?
Sorry, P291?
Sorry. 290.
290.
From line 28. She goes on to say, is it your evidence that you're not aware of any, future risk that the Legal Services Board is alleging that I will breach the uniform law? Mr. Anstee's answer. I think I've already to some extent answered that question. Fundamentally, I'm not comfortable answering that question in detail without seeing materials before me. And I understand that the evidence in relation to conduct and arguments in relation to risk is in other evidence.
Yes. I'm not going to allow you to put this document in, Mr. McAuliffe. In my view, it doesn't properly arise out of that. That cross-examination does not open the door for you to put a whole lot of other materials to Mr. Anstee and get further evidence on it. It would be unfair to Ms. Shu. She would then have to be given leave to re-cross-examine on it all, and so forth. It's that, in my view, what you're trying to do in substance is to lead evidence that really should be evidence-led in chief, rather than in re-examination.
Well, no, I don't cavil with that, Your Honor.
All right, thanks.
The difficulty that I face is certainly that wasn't led in evidence in chief, and then it has arisen in cross-examination, as to seeking to confine the evidence this witness.
Cross-examination has identified an area where there is no evidence. That doesn't mean, in re-examination, you can just lead that evidence.
No.
Part of cross-examination was effective to circumscribe the nature of the evidence that has been put against them. And, what you're now saying is, having had it circumscribed in that sense, I want to step outside that circumscription.
I apologize, Your Honor, but I respectfully disagree.
That's all right.
The purpose of the cross-examination has been to circumscribe it, but it has been done, I would suggest, with knowledge, and having these materials already disclosed to the defendants. And so, if Ms. Shu, in attempting to say through Mr. Anstee, is that there is no future risk, then I have to be able to meet that, because that wasn't put in our opening submissions. That sort of allegation. And she has attempted to circumscribe it, and I would say, having already receipt of these materials that demonstrate, I would submit, that there is such a future risk without an injunction in place.
No, I'm against you, Mr. McAuliffe.
Very well, Your Honor. I have no...
I'm happy to re-examine, if...
No, you just...
I just put my position, if...
Ms. Sue, I have ruled not to receive into evidence. I am going to change my... I think I had indicated I was going to receive this, what I had referred to as Exhibit D, I think, into evidence. I think the more appropriate ruling for me to make is just not to receive it, Mr. McAuliffe.
That's so, Your Honor. That would be the appropriate ruling.
Thank you.
If, yes, might then it be appropriate if that, Your Honor, is handed back?
Yes.
Yes.
Do you not want...
You can keep it if you want. And from the witness, thank you, Your Honor. Thank you, Your Honor. There's no further questions in re-examination.
Thank you, Mr. Anstee. Thank you. You're excused. You can come and go as you wish. All right, now...
So the next witness is Ben Davidson, Your Honor. Now, given the nature of the time with today, I would just seek Your Honor's leave with a number of matters. First, is that we just proceed straight. Well, I read his affidavit, but proceed straight to cross-examination, and return to take.
Yes, I think that's appropriate.
Thank you, Your Honor. That's the first matter. The second is, formally, I would need to seek Your Honor's leave, essentially, to replace the affidavit of Ms. Cesare with that of Mr. Davidson.
Yes.
Yes.
Am I right in thinking that Mr. Davidson's affidavit effectively reproduces the documentation that was exhibited to Ms. Sex's affidavit?
It does for the documentation. There are some slight differences in relation to the affidavit evidence itself.
Yes.
For example, I read this affidavit. He says, for example, that he personally receives these emails, where Ms.
Yes, but he does not purport to give evidence beyond relevant evidence, beyond the production of the documentation.
No, he does not.
Ms. Shu, any objection to me receiving the affidavit of Mr. Davidson?
No, but...
Thank you.
I think we have received it at a very short notice.
Yes, you have.
So do we have to cross-examine him?
Yes.
Right now?
Yes, you do. Mr. Ansel, any objection?
Yes, Your Honor, I haven't.
Well, what's the...
Confirmed in detail that it is. It's exactly the same as, which is what.
Well...
I think, Counsel is saying, plus a few minor. I don't know what the minor differences are.
No, we'll have a look at it now. I mean, both documents as I read them merely produce correspondence.
I understand that, Your Honor.
And the explanation is that Mr. Davidson was overseas when this matter was first going to be heard. So Ms. Cesare, who is his junior, swore the first one. And she's overseas, but he's here now, so he has sworn this one. But they are both. As I was trying to say to Mr. McAuliffe before, this case against the three of you is based on documents, and this is producing the documents. So I don't see there to be any prejudice.
Well, Your Honor, the only point I'm making is in relation to, are they exactly the same?
Well,
No, I haven't had a chance to compare the Ustus
all right.
the documents,
Well, you have.
and that's.
Well, I will grant leave to the plaintiff to rely on the affidavit of Ben Davidson, dated the 15th of August 2024, that produces those documents.
Thank you, Your Honor.
You've had the assurance, Mr. Ansell, that the documents produced are the same. If when you look at it, there's some substantive difference that you wish to raise, I will hear you.
Yes, Your Honor. Counsel did say that there were some differences, which.
I know, but the difference is, I received this document rather than.
I'm sorry, I thought he was referring.
Miss Cesare is saying, my.
I thought he was.
Mr. Davidson received.
Referring to the content, Your Honor.
No, the as I understood it, and that's what Mr. McAuliffe has confirmed. It's just those modes of expression, so to speak, to accurately reflect that it's the partner, not the solicitor, that is swearing the affidavit.
Thank you, Your Honor.
Thanks, Mr. Ansell.
There's a second matter that arises, where leave would have to be sought as well, in relation to Mr. Davidson's affidavit. This hasn't been flagged yet.
This is, yes, the length of the affidavit?
This is a new, if, apologies. Then, a third, there will be another matter to seek. That will be, the length of the affidavit will be an issue. The first is an issue for which my instructor and I will have to apologize, but Mr. Davidson's affidavit is a so-called wet ink affidavit. He swore it on paper. Miss Cesare swore it virtually, no paper exists of it. There is metadata in the affidavit, in the exhibits, which were produced by Miss Cesare, which we sought to, we will seek to rely on some of that information. And that, unfortunately, has not come across in Mr. Davidson's wet ink affidavit. So, Mr. Davidson is able to produce the exact same wet ink affidavit, electronically, that does contain that metadata.
Well, give me an example of the metadata.
So there are, for example, in some of the exhibits, such as the letter or application as to costs, which is particularly important in the case against Mr. Ansell.
Yes,
Referable to signatures that demonstrate that the author of those signatures is a person under the name of Shivesh K, and it indicates the time and date of those signatures.
I didn't pick that up in the Miss Cesare's affidavit at all.
It is in the comments pane on Adobe. It's that metadata is available.
Well, I take the view, in accordance with my before, that if Mr. Davidson is essentially exhibiting the documents that were previously exhibited to Miss Cesare's affidavit, that's okay.
Thank you, Your Honor.
In terms of the length of the documents, I'm inclined to grant you leave to rely on them, notwithstanding they exceed the page limit, because, having looked at them, I have taken the view that they are not oppressive in their length, but I will hear what Ms. Yu has got to say about that.
Court pleases.
Ms. Shu?
Sorry, I
2.
didn't get it.
There's 2.
What is the
2 aspects. One is, the affidavit of Mr. Ben Davidson produces everything in paper only, and so some of the metadata of his exhibits, some of the metadata that was on the Cesar set of exhibits, isn't in the Davidson set of exhibits. And I've indicated, subject to hearing from you, that consistently with what I said before, because Mr. Davidson's affidavit is essentially reproducing the material that was already produced by Ms. Cesare, and he was sworn it so that there's somebody here to be cross-examined here, if required. I would permit the metadata that has previously been exhibited to Ms. Cesare's affidavit to be treated as if it's part of Mr. Davidson's affidavit, so to speak.
Can they identify which pages?
In due course. I want to move on with Mr. Davidson. We might part this when you've had more time to think about it. The other aspect is I made an order that the exhibits of the affidavits are not to exceed 100 pages. The exhibits in this affidavit do marginally exceed 100 pages. It seems to me that an attempt has been made not to spend too many pages on silly documents, and that the length of this affidavit is not oppressive. I note that no complaint was made by you, or Mr. Ansell, or Mr. Kuksal, in relation to the length of Ms. Cesari's affidavit. Is there any reason why I shouldn't receive Mr. Davidson's affidavit, notwithstanding the fact that the exhibits are 100 and nokampa?
32.
The exhibits are, 120 pages odd, 13 of which are the ASIC report, or more, 15 of which.
I don't think that they have raised it when they served the affidavit.
No, do you have any reason why I shouldn't receive the affidavit?
I think there were orders made.
There was orders made that they had to be limited to that, but that people could ask to be excused from that. Predetermined.
Yes, but then they didn't ask.
Well, they're asking now.
Well, I did, Your Honor. We asked in the written submission.
Yes, that's right, the written submissions.
Which is much after.
Yes, the written submissions which were filed in advance of the hearing referred to this matter, and indicated they'd be seeking that leave. Do you oppose it, and if so, why?
Well, yes, I do. But if Your Honor is...
Well, tell me why.
Because every time we file the documents, we get extremely prejudiced by the registry. They just simply say no to me, or Mr. Kuksal if they see it's our documents.
Okay.
And they simply refuse and say refer to judge's order, too big.
All right.
And it's just another reflection of the unfairness that we have been continuously receiving from the courts.
All right.
Both from the judge and the registry, that's all the documents.
All right.
If the Legal Service Board is filing it, then they get accepted, results, I think. And when we were filing it, I have to call them and then get hang up multiple times and get very rude treatment.
All right.
Well, I get that Your Honor is going to accept it, but I do oppose for the sake of...
Thank you, Ms. Zhu.
Your Honor, can I just correct something Ms. Shu has said? In Your Honor's orders of the 4th of June in this proceeding, Your Honor ordered, by paragraph 14, that in any event that either party wish to rely on affidavit material that exceeds those page limits, they shall file and serve by 4 p.m. on the 29th of July.
I'm just looking. I have read the submission where you deal with it.
Yes.
What paragraph?
It's under from paragraph 5.
5 leads to it, yes. All right. Mr. Ansel, have you got anything to add to Ms. Shu?
I have nothing further to add, Your Honor.
All right. I previously ordered that affidavits filed in this proceeding contain exhibits of no more than 100 pages. I provided, by my orders, a mechanism whereby, where a party seeking to rely on an exhibit with more pages than that, could seek leave of the court. I made an order by which that should be communicated. The plaintiff filed an affidavit by Ms. Cesari that exceeded the page limits by a relatively small amount, in that the exhibits were about 120 pages, rather than 120 pages. In a written submission filed by the plaintiff dated the 19th of July 2024, the plaintiff indicated their application for leave, notwithstanding that the annexes exceed the page limits exposed. The reasons put forward included the fact that most of the annexes are extracts of correspondence or affidavits created by Mr. Ansel, and they said an effort had been made to confine the material. Having looked at the exhibit to Ms. Cesari's affidavit, which is substantially the same, or is the same, as the exhibit to the affidavit of Mr. Donald Davidson of the 15th of August 2024, I propose to grant the plaintiff leave to file and rely on Mr. Davidson's affidavit. Ms. Try, in a submission adopted by Mr. Ansel, objected to me granting that leave, because of what she said was an unfair and different treatment by the court, in relation to the length of documents that would be accepted for filing. Neither Ms. Schroer nor Mr. Ansel identified any prejudice in terms of the particular documents that were provided. Having looked at the exhibit, I am satisfied that reasonable endeavors were made to reduce any unnecessary length of the exhibit, and that an inclusion of the documents in the exhibit was not oppressive or overly onerous to the defendants. Yes.
I call Benjamin Donald Davidson.
Thank you.
Thank you. Could you please restate your full name for the record?
Benjamin Donald Davidson.
And did you swear an affidavit in this matter on the 15th of August 2024?
I did.
Do you have a copy there, Mr. Davidson?
I do not.
I might just seek leave.
Yes, we'll put it up on the screen, Mr. Davidson. Something should happen on that screen in front of you, and we should all see it on the big screens on the court. I should have said, but I'm sure you know this. Sit or stand as you feel most comfortable. If you need a break, or need a question repeated, just let me know. Bye, D.
Thank you, sir.
Do you have in front of you there
I have it on the screen.
Thank you. If I could just ask Your Honor's associate to take Mr. Davidson through to P11 to the final page. Mr. Davidson, is that your signature swearing this affidavit?
It is.
Are there any changes you wish to make to this affidavit?
There are not.
and your affidavit produces 6 exhibits to it?
It does.
And is that affidavit true and correct?
It is.
Thank you, Your Honor. I tender the affidavit.
I think there might be a second affidavit of that date, so I'm identifying it in that way.
Thank you, Your Honor.
Thank you, Mr. Ansel. You're the highest-ranking defendant, so to speak.
Next in line,
Yes.
Your Honor, as I've indicated, I think Mr. Kuksal was leading me.
Do you wish to cross-examine?
I'm not cross-examining, Your Honor.
Thank you.
Mr. Kuksal was actually going to cross-examine.
Mr. Kuksal is not here. Ms. Shu.
Yes. So, Mr. Davidson, first of all, if you have any problems understanding me, you can ask me. Okay. So, what's your involvement, your role in relation? In this proceeding 03994.
I'm a partner of the firm Cause Chambers Westgarth. We are instructed by the board, and I have the care and conduct of the matter subject to several of my solicitors.
Subject to, sorry?
Several of my solicitors who are working on this matter as well.
Can I request you to speak a louder?
Slowly.
And slowly, sorry?
Sorry. So I'm a partner of the firm. I have care and conduct of this matter for the Legal Services Board. And I'm working on this matter with several of my solicitors.
Okay. Several of your, do you review documents, all of them, or is it that you will just take advice from your junior solicitors?
Not all of them. As an example, I've just been away for 3 months, 2.5 months, so there's a series of documents I haven't reviewed that one of my partners may have reviewed, Jane.
Okay. And was the other 2 solicitors, they are under your supervision, and you must supervise them, is that correct?
Correct.
Okay. Thank you. So, are you part of the discussion, if any, with the clients, the Legal Services Board?
Sometimes. Not all of them.
So some of them they are, and that's it, between the Legal Service Board and Mr. Amaran?
Correct.
Okay, so with regards to receiving documents and you're producing them, how do you obtain those documents?
In respect of this affidavit?
Yes, the exhibits in this affidavit?
So, Ms. Shrew, this affidavit was compiled in fact while I was away and sworn by Ms. Cesare. When I returned, and it became apparent that this trial would proceed in her absence, and while I was back, I re-swore the affidavit based on the material that Ms. Cesare had compiled. So I reviewed that material, and swore that as an accurate affidavit.
Okay. So obviously she has obtained the instructions from the clients?
Correct.
And it is supposedly decided that those are the documents that the Legal Services Board wants to adduce, or want you, as the solicitor, to adduce.
Correct.
Can I ask, why would the Legal Services Board or your clients not produce those documents not by themselves, but by you?
Sorry, what's the question, Ms. Shu?
Why would they want the solicitors to adduce documents instead of themselves?
What's the objection, Mr. McAuliffe?
If it shows that the matters are privileged, then I would object because if it's asking about why certain decisions are being made, Mr. Davidson sworn the affidavit, and this is where we are.
Well, can I say, Ms. Shu, there's a number of points. One is, some of these documents were sent to or from cause, Mr. Davidson himself, and you can't ask questions that require Mr. Davidson to disclose advice that he's given to his client. But what is the relevance of the question?
So what I'm trying to say is that I am not sure if I should have Mr. Davidson here. Okay, it's fine. It will be quick.
You tell me. I mean, if you're going to say something in your discussion with me that you don't want him to hear, I can ask him to leave, but if you're not going to say that, I won't. I don't know what you are going to say.
Can I request that Mr. Davidson be?
Mr. Davidson, do you mind just stepping outside for a moment? Thank you.
Thank you. So the point is that I think I've raised this before, is that the decision for the Legal Services Board to take actions against me is a decision made by a specific party, and they're called the local authorities, and only Legal Services Board can take actions under S 447 of the Uniform Law. If Mr. Davidson is acting as the Legal Services Board solicitor, he is no acting as an employee of the Legal Services Board.
Yes.
So he's not an investigator to collect evidence against the defendants. So, if the board is using anything to or anything against the defendants and said that those are improper, then I would say that it would be appropriate for themselves, whoever is conducting the investigation or whoever had the conclusion that something you've done is wrong, and me as the investigator or a regulator are taking actions against you. But I will say for me it is not appropriate for Mr. Davidson, who acts as a legal representative of the Legal Services Board, to receive emails of complaints or any evidence. He would be acting as an employee or a delegate of the Legal Services Board to conduct the function of regulating or investigation, and I say that's not proper. I'm not saying I haven't got to whether or not adducing those evidence are proper or not. I'm saying that his function should be only limited to give legal representation or give legal advice to the Legal Services Board about conducting this proceeding. He is not to either collect evidence or, do an investigation, but...
So the question you're asking him is, why is he swearing this affidavit, rather than someone from the Victorian Legal Services Board?
Yes.
And how could he answer it in a way that would be relevant to what I have to decide? He'll ever say, we discussed it and I can't tell you what it was. Or he can say, what matters in this case is the documents that are being produced. The case against you is a documentary one.
Your Honor, can I?
So you want to run an argument that the whole claim is misconceived because it has been run by Corus Chambers Westgarth, not by the Victorian Legal Services Board.
What I'm saying is that it's not, okay, can I have 5 minutes to...
No.
Make the submissions.
Yes, I thought you meant a break. Yes, tell me.
Okay. So my rationale is this, is that the case they're running is that the regulator of the legal services is taking actions against me and say that I have committed an offence.
Yes.
Under the uniform law. So, in the normal circumstance, somebody in charge from the Legal Services Board, the regulator, would come to the court and say, here is the allegation, here is the evidence, this is what we allege that she's done wrong, this is the risk. Whether or not want her or not, I have formed the view that I, as a legal services regulator, have formed the view that she isn't, a big risk. Then I ask the court, as someone from the Legal Services Board, the regulator, under S447 of the Uniform Law, to impose an injunction. Right now, the situation that I'm facing is that none of those deponents are willing to make that assertion. What they are doing is they produce the documents, but they are not wanting to be cross-examined by me, and then they are leaving the job for making allegations to Mr. McAuliffe. Who is taking instructions from them.
This is the way I see it, Ms. Accuser. The Legal Services Board is entitled to lead evidence in ways it wishes to lead the evidence, including the way it has. You can run an argument, in your final submissions if you like, that the proceeding is defective, because there hasn't been evidence called by the Victorian Legal Services Board as to what it wishes or seeks or fears or hopes for. But that's a matter of submission, rather than a matter for cross-examination of Mr. Davidson.
But I have the difficulty that I must and I will face is that, can I just give an example?
Yes.
For example, just an example, okay? If someone from the department, and saying that, come to the court and say that, our department wants to take the kid away from the parent.
Yes.
Because he's, abusive,
Yes.
beat up the children every day and...
Yes.
There's a lot of ongoing risk.
Yes.
So somebody from that department is the person in charge, or has the experience. That person can come to the court and be the witness, and...
Yes.
Tell the court that this is the application that I make to the court, and because of the facts, the legal reasons, my analysis, all sorts of things, that's why I am asking the court, as an employee of the department.
I understand your point. What you're saying is that you're raising for consideration why there isn't an affidavit from the Victorian Legal Services Board itself. Someone there saying, in my view, an injunction is necessary against Ms. Sue for these reasons. Now that might be a very good point, that might be fatal to the case, I don't know, and you can argue that. But the evidence is what the evidence is, and if there's a failure in the board to lead evidence that you say should or had have been led, that's good for you, and you can raise that argument. But I don't see how... I don't see any benefit in asking. I don't see how Mr. Davidson can give relevant evidence on that fact.
Again, Your Honor, just so very, very quickly. And I said that this is the issue that I will face, and is a very detrimental...
But the issue you face...
Because of,
The issue you face is that there's no evidence from the Victorian Legal Services Board itself, on the matters that you say there should have been evidence on.
Yes, and I can't cross-examine them.
Okay. But that's...
That's
because...
Mr. McAuliffe.
That's because there's no evidence.
Yes, but then Mr. McAuliffe will use...
He will present argument. He won't lead evidence. He will present argument on the evidence that is led.
No, Mr. McAuliffe will make those allegations. He will be the person that normally you expect a police informant or the investigator. He will say those things based on the documents, and then draw Your Honor's attention to those, and then, ask Your Honor to draw more inferences.
Yes.
On what's done. Then I cannot cross-examine
Okay.
the real regulator,
Yes.
and the person who is making the allegation.
Look, I can understand, I think, where you're
So,
coming from, Miss Shu. But I can tell you it's not a proper area of cross-examination of Mr. Davidson. So we will bring Mr. Davidson back in, please. Thanks. Yes, Ms. Zhu.
yes. Mr. Davidson, are you aware of your client's allegation against me?
Yes.
And do you agree that, it is through you they want to make those allegations?
Well, no. They've asked me to swear an affidavit with the relevant documents that support that allegation.
What are the allegations against me, just briefly, or in a general term if you can?
I think, in genera.
Miss Quirwa, but why? Why? Why have Mr. Davidson repeat his understanding of the allegations that are brought? I mean, if Mr. Davidson says, I think that Miss Shu poses a real risk to the community.
Yeah, but no, Your Honor.
And she should be stopped.
Yeah.
I would say, I'm not interested in your opinion, Mr. Davidson. If Mr. Davidson said, Miss Chu is a wonderful woman who should be getting an Order of Australia, I would say, I'm not interested in your opinion, Mr. Davidson. All I'm interested in is what the facts demonstrate.
Yes, Your Honor, I understand.
Not opinion.
But
Not opinions of a solicitor who is acting for the board.
But then who will be running the opinion? It's either the board.
The board will be making a submission about what it contends I should find, on the evidence. And you will be making a submission, saying what I should or not find, on the evidence. And what, Mr. Davidson? I will let you ask questions to see if it's going somewhere else. But I can't see how anything Mr. Davidson says on that point is going to help, or hinder, have any, will be relevant to the facts in issue. The facts in issue are, what were you doing? What was Mr. Ansell doing? What was Mr. Kuksal doing? What was People's Shop doing? And Bray, was what you were doing right or wrong? And if it was wrong, should something be done about it?
That's not what the Legal Services Board is asking. To begin with.
Well, so ask your next question. Ask the question and...
Okay, Mr. Davidson, can you just tell me what is your understanding that the Legal Services Board's allegation against me?
I will allow the question, just provisionally, so to speak, and we will see where it goes.
The board considers that there are breaches of S10 and 11 of the Uniform Law in respect of the conduct of the three defendants, in respect of the erudite law and its engagement, in emails, and a series of other events that have either represented, that they are engaging as lawyers, or are entitled to engage as lawyers, or have actually, suggested that they are lawyers, in circumstances where they're not admitted.
And when you say they are lawyers, you mean specifically Mr. Ansell?
Correct.
So just more specifically, against me, can you just tell me what's the allegation?
As I understand the allegations, they are that there is a breach of the Act in respect of representing that you are engaging in legal conduct.
That I am engaging in legal conduct, as in that I...
But, see Miss Sue, this is where I allowed the question, and it has gone down. It's going down a path that is not, which is designed to extract answers that are not relevant to a fact that I have to decide. As I say, I am not that interested. With the greatest respect to Mr. Davidson, it's just not his role to express in evidence what he thinks happened, or what he thinks didn't happen, or what he thinks is being said against you, or isn't being said against you.
Your Honor, so the thing is that, what Your Honor told me today and yesterday was that Your Honor is not interested in what the Legal Services Board is saying or their opinion is. It matters what you think eventually.
Yes.
But what I'm saying would be that it is really the only that matters, because you can only hear their allegation first, and that I can only respond to their allegations, and if you have any other opinion, or if your mind goes somewhere else, then I cannot deal with it.
Ms. too, have you read the opening submissions that were provided by the Victorian Legal Services Board on the 19th of July? I mean, that is sort of, in a sense, setting out what they say, at least in part.
That, Your Honor, that is so, but to have them only producing the documents will leave me no opportunity to cross-examine them with the operation of their investigation, and I'm not going into the conspiracy anywhere close to that, because if so, I would have started with the Channel 9 things.
Can I tell you, Miss Shu, in my view, Questions directed at Mr. Davidson about what he understands the board's position to be in relation to you are not admissible, are not proper questions.
Okay, Mr. Davidson, can you go to paragraph 10 of your affidavit?
We'll bring it up on the screen, Ms. Zhu.
Yes. To witness. So, paragraph 10, you said that from the commencement of this proceeding, the date of this affidavit, I've received emails from the law practice email domain of eruditelegal.com.au from at least the following email accounts, and you've listed them. Can I ask you why you haven't exhibited any or all of the emails from all of those email addresses that's listed?
Why I haven't exhibited all of those emails?
Yes. So, you said you have received emails from Maria at eruditelegal, at eruditelegal, at eruditelegal, Peter Legal, contact and reception at eruditelegal. So why did you not exhibit them to this affidavit?
Well, because there would potentially be hundreds and hundreds of emails.
You've done a very smart thing of, just taking a small part of those email addresses with dates and things. So if you are really saying that you've received emails from all of those email addresses, then why wouldn't you exhibit it?
Well, as I say, there was a page limit on this affidavit, and that would produce hundreds and hundreds of emails that I don't think were germane.
Sure, but then can I say that's you? You are unable to provide specific evidence to say that's you have received emails from all of those A to G email addresses?
I don't know. If I give that evidence in that paragraph.
And, okay, but you are not going to exhibit them?
No.
Do you want to change any of your evidence about this paragraph?
No.
Okay, then can you go to paragraph 12? So the title is Documents Received of a Legal Character. So can you explain to me what does a legal character mean?
Well, it means that those documents read objectively, appear to have a legal characteristic to them.
I apologize. I am not very legally equipped, so I do not understand what legal character means in your affidavit. So if you can explain to me, that would be helpful.
It means that if a normal person were to read these documents, they would apprehend them to be legal in nature.
Legal in nature as in, they are sent in relation to a legal proceeding or about a legal proceeding, or there are parties of a proceeding, or that they are acting as lawyers, is what you're saying.
What I'm saying,
when you say legal character.
Sorry, can I just interrupt for a moment, Ms. Zhu? I'm sorry to do this, but the question you asked about paragraph 10 made me do it. I'm just comparing Ms. Cicera's affidavit with Mr. Davidson's. Paragraph 11 in Mr. Davidson's, it says, since the interim injunction orders of the Honorable Forbes J., dated the 21st of October 2022, I have received emails from the email address of Peter at eruditelegal.com.au. What Ms. Cicera swore is that since the interim injunction orders of the Honorable Forbes J. dated the 21st of October 2022, I have only received emails from the email address of Peter at Erudite Law. So Ms. Cicera's affidavit made it clear that what Mr. Davidson has put out in paragraph 10 was subject to paragraph 11 in a sense. Is it the situation, Mr. Davidson, that you also, since the interim injunction was made, have only received emails from Peter at eruditelegal.com.au?
I think that's correct, Your Honor.
Ms. Zhu, have you followed what I've been saying? I think you've picked up a difference between the two affidavits. Unganif and alax. Tuatiman kadaks.
I will take note, and just for the interests of time, if...
Mr. McAuliffe, I've sort of taken over in a sense as your witness. But would it be correct, Mr. Davidson, for us to read your affidavit? Perhaps we'll just bring paragraph 11 up again. And if you want to say Ms. Sex's affidavit, I can show you. You've got your counsel here. Should that second line on paragraph 11 read, I have only received emails from the email address of Peter at Erudite Law.
I think that's correct, Your Honor. I say that without having a computer in front of me to do a search for those things, but I think that's correct.
All right, before you make that concession, do you want to see Ms. Cicera's affidavit or are you happy?
No, I've seen Ms. Cicera's affidavit.
Yes.
Yes. I'm happy to make that concession.
Okay. So, Ms. Zhu, we will treat Mr. Benjamin Davidson's affidavit as if the second line in paragraph 11 reads, October 22nd, I have only received emails from the email address of Peter at eruditelegal.com.au.
Yes, that's fine, thanks.
Thanks for identifying that, Ms. Zhu. Now I'm sorry, you'd asked another question that I cut across.
Yes, so I was asking Mr. Davidson. I'm seeking his help to help me understand in his affidavit, what does a legal character mean? Does it mean when you say about the legal proceeding, or, sorry, I forgot your words.
What do you mean in your affidavit when you use the phrase legal character?
that the correspondence that is being engaged in, referenced in Exhibits 3 onwards, Evidence is correspondence which is legal in its nature. It is engaging in legal submissions, legal issues, legal topics. For and on behalf of each of the defendants, from each other. From each other.
Okay, but do you suggest that that's a suggestion? That's how you conclude that the defendants are asserting an entitlement that they can practice law. Is that what you mean?
I don't make that assertion.
You do not make that assertion?
No, I don't. I don't.
By adducing these email address.
No.
Okay?
No, well, not about you.
Okay?
There is a separate provision about Mr. Ansel.
Okay. So I just confirm again. So that when you say legal character, that means it's just anyone can make legal submissions, right? I can, as a non-lawyer, and if I'm involved in a legal proceeding, I can send documents or emails or whatever about legal proceeding, or...
I think what you're being asked is, do you accept that documents of a legal character may on occasions properly be prepared by somebody who is not a lawyer, if they're a party to the litigation?
And I think that's correct.
Yes.
Okay.
Is that?
Yes.
That's your point, isn't it? That you want an acceptance.
Yes.
That the fact that if you are a party to a litigation and you file a document in that litigation, it will be a document of a legal character, but that does not, of itself, means that you're pretending to be a lawyer.
Or that I am asserting that I am, for example, working for a law firm, and I can provide...
Yes.
Legal service.
It may or may not, depending on what the document says, presumably.
Yes.
Yes.
So it's just what this legal character means.
Yes.
If it's that a layperson, or if a layperson can send...
Yes.
Documents of a legal character, is what I try to understand from your use of words. I think...
Yes.
We get there. So you do not say that. Sorry, I think I've received some assistance from the court, so I won't repeat that question. So in paragraph 13 here, so this is still under the legal character. Do you have the physical documents? Yep, okay. So this is still under the big title, documents received of a legal character. So this is paragraph 13. By way of an example, so you provided a screenshot of an affidavit sworn by Mr. Ansel, that's in another proceeding, that you have received, where your client is also a party?
Correct.
The first question is, did you seek the parties of that proceeding's permission to use that affidavit to be used as evidence in this proceeding?
No.
Well, one of the parties is the Victorian Legal Services Board. Well, when you say the parties, did you mean...
Parties as...
Did you seek Mr. Kuksal's the plaintiffs?
Or my permission, yes.
Yes, all right.
And you believe that you do not have to seek permissions? Or do you have reasons for why you don't have to seek permissions? Or you think you just don't need to seek permissions at all? Or just for that specific documents, you don't have to?
Ms. Shu, I assume you're talking about the Harmon undertaking.
Sorry?
I assume you're speaking about the Harmon undertaking. Is that the permission that you're talking about?
Yes?
So I had formed the view, and I believe, Miss Cesare before me, that this document is not captured by the Harmon undertaking.
So your view is formed based on what Miss Cesare had told you?
What Miss Sati? Well, I know what Miss Sati thought, and I have also formed the view that this is not captured.
Is it possible that you can provide a reason why it is not?
Well, again, Miss Shu, you can. Look, I will allow the question, was on the yenia.
Well, Your Honor, I haven't objected to this far, but we're really just getting into a point where we're seeking respectfully Mr. Davidson's opinions about things that are properly legal submission.
Yes, look, I think it's a legitimate question for Ms. Gruer to ask, did you obtain permission?
Yes.
And the evidence has come out that they didn't obtain permission, or permission wasn't sought. Beyond that, Ms. Guzu, it's then a question of argument, isn't it? Unless there's some piece of evidence you want to extract about the circumstances that would be relevant to that issue, just the opinion itself is not.
Yeah, okay, alright, I will leave that. So still in paragraph 13, you said that the heading of that affidavit states that it was prepared by Erudite Legal, and it was filed on behalf of the plaintiffs. The contact email address is peter@eruditelegal.com.au. And you say that is a legal character, because it's still under the heading of the legal documents received of legal character. So,
yes.
Do you want to change your definition of legal character?
No. It's similar to the emails in 11 or 12. I'm sorry. I can only see paragraph 13. In that.
So you say that.
Sorry, he was just finishing his answer. He asked to see the previous paragraph.
All right.
It's similar to this, in the sense that, while I accept that, as a party to this proceeding, you may end up writing an email which is of a legal character, but these are similar to that affidavit. This is one of the parties purporting to represent all the parties and make legal representations on behalf of all of them. So this is similar in the affidavit.
Sorry,
Again, Miss Sue, that might be right or might not be wrong. It's for me to decide, at the end of the day.
Yeah,
I'm not sure what the point of.
I just asked Mr. Davidson because previously, he said that documents of a legal character can be given by a layperson.
Yes. And then here's an example that says, prepared by erudite legal.
Yes, and he said that's a.
But it doesn't say, prepared by Miss Shu. Or Mr. Kuksal.
I understand that. But so what I'm asking him is if he wants to change his definition of legal character.
Okay, well you asked him that, and he said he didn't, I think.
Yes, that's what I want to ask him. If he said that's because he previously defined that legal character, or documents of a legal character, is something that's just, you're involved in a legal proceeding. Yep, that's why I ask if you want to change your definition of legal character, or documents of a legal character.
No.
Okay, thank you. And, Mr. Davidson, you yourself do not make allegations against the defendants. Drowawa.
Well?
No, I do not.
But I am worried, Miss Shu, that you will misunderstand the answer.
Okay, sorry, yep,
When you say.
Yes,
When you say he doesn't make allegations, the allegations are made by the board. He produces documents in this affidavit that are relied on by the board in support of its allegations. So I'm not quite sure that it's clear what you mean by saying that Mr. Davidson doesn't make allegations. I mean, he says he doesn't because strictly he doesn't. He's a lawyer acting for the board. But are you trying to say that?
The argument I'm trying to make is that he doesn't make allegations directly through his affidavit, or through his evidence.
Other than by producing the document.
Yes, other than producing the document to imply that something. Yes, he is not implying something.
Look, I'll let you ask that question, Miss Sue, but before you ask him to answer it, I can tell you that as I read his affidavit, it's clear that he is not himself purporting to express a view on the matter. He is simply producing documents and explaining where they have come from. So I'm already on your side in the sense that I'm of the view that Mr. Davidson is not himself in his affidavit making. In the body of his affidavit making allegations, he's simply producing the material on which his client's going to make allegations. But so that's the way I understand it. You can ask the question if you want, but that's where I'm at the moment.
Yes, I understand. I would just have that recorded.
Yes.
In the transcripts. Okay, so, go.
I should. Mr. McAuliffe, is that common ground?
It is, Your Honor. It is.
All right. No, that's fine. Mr. McAuliffe will accept that Mr. Davidson's affidavit is being relied on for the evidence it gives in relation to the production of the documents, and where they come from, and the like. He's not going to be saying to me at the end of the day, the board should win, because Mr. Davidson says that Miss Chu has done the wrong thing.
But my argument would be that when he said, and I understand when he say documents of a legal character, he necessarily implied that.
Right. Well, I think you've clarified that for him legal character means a document associated with court proceedings.
Yes.
And it may or may not be an appropriate document if you know what I mean.
I don't.
Depending on what it says.
Okay. Yes. So, Mr. Davidson, can you go to paragraph 90 of the affidavit? So I have also reviewed affidavits of Mr. Ansell, where he described himself as a lawyer. Yes. Tartan me.
That's correct.
So again, you're not implying anything is wrong here. You're just saying that Mr. Ansell has described himself as a lawyer?
They're a factual set of documents that I introduce into evidence, and simply point to that observation.
That's correct. Do you agree that Mr. Ansell is a lawyer?
No, he's not admitted.
Sorry, can you repeat it?
No, he's not admitted as a lawyer at the present time.
Well, do you mean he doesn't have a practicing certificate?
Doesn't have a practicing certificate.
Okay.
Depending on what it says.
Okay, yes. So Mr. Davidson, can you go to paragraph 90 of the affidavit? So I have also reviewed affidavits of Mr. Ansell, where he described himself as a lawyer. Yes.
They're a factual set of documents that I introduce into evidence, and simply point to that observation.
That's correct. Do you agree that Mr. Ansell is a lawyer?
No, he's not admitted.
Sorry, can you repeat it?
No, he's not admitted as a lawyer at the present time.
Well, do you mean he doesn't have a practicing certificate?
Doesn't have a practicing certificate.
Okay. Can I ask you, when you say in this paragraph where he described himself as a lawyer, do you want to say that he is not a legal practitioner? Or have any of those indications when you say he described himself as a lawyer? Okay. Give me.
I object, Your Honor. The question has been asked and answered in the sense that Mr. Davidson has said very clearly what he's doing in this paragraph. He's producing these documents and he's just pointing to this matter. That's apparent on the face of the document. He's not making legal argument in his affidavit.
Yes. What is your point with the question, Mrs. Shute?
The point is that there is nothing incorrect.
Well, that's something you can present an argument to me. What I'm asking is, why does anything Mr. Davidson? Why does it matter what somebody else thinks about that? You're going to argue to me that there's nothing wrong with Mr. Ansell describing himself as a lawyer, and Mr. McAuliffe is going to say there is something wrong with Mr. Ansell describing himself as a lawyer, and I'll have to decide. But what Mr. Davidson thinks is not really something I'm entitled to have regard to.
Okay. I will go to the next paragraph. So paragraph 21. So here you refer to a part of the affidavit that's sworn by Mr. Kuksal and witnessed by Mr. Ansell.
Migsu, is that a question, or are you waiting for an answer, or are you finishing your question?
Actually, I will pass that one because I think I misread something, so sorry about that. And paragraph 22. You said you have been provided with affidavits of Mr. Ansell by the Victorian Government Solicitor's Office dated the 16th of June 2023 to a Magistrates Court proceeding L10768590, indistinct, Mr. Kuksal. In what capacity do you receive the document?
As I understand it, that document was produced by the VGSO to the board, and from the board to the solicitors, and in particular Ms. Cesare. So it has come to my hands.
So you were provided.
Sorry, let him finish.
Sorry?
It's come to my hands via that path, from the VGSO.
When you say you have been provided an affidavit of Mr. Ansell by VGSO, it sounds like that VGSO give you the documents because you say, by VGSO, right?
It has come from the VGSO, correct.
So, how do you have the document, or how do you or Ms. Cesare have get the document?
I think I just explained that. It came.
Okay. So, is it that's the VGSO provided to the Legal Services Board, and the Legal Services Board provided to you, or did the VGSO provide it to you directly?
No, they did not provide it to me directly.
So, you have been provided an affidavit where Legal Services Board is not a party, or in a proceeding where Legal Services Board is not a party.
That's correct.
And your client has provided this document to you and asked you to adduce this document?
That's correct.
Did your client make any attempt, or have you made any attempt, to contact Mr. Kuksal and told him that these documents will be used in the legal proceeding?
I have not. And I'm not aware whether the board has.
And you believe that you do not need to seek permissions in relation to this affidavit?
I do not believe that affidavit is subject to the Harmon principle. No.
So you do not think that it's necessary to inform the parties that their affidavits have been used in a Legal Service Board's proceeding?
No, I do not.
Okay. And when? Do you know when did you received, or when did your client receive the documents from the VGSL?
No, I do not.
When are you provided by the Legal Services Board of this document?
I believe it was whilst I was away, so it was.
So when was that, sorry?
I was away for most of June. Back end of June, July and August.
So you just came back?
Correct.
Okay. Have you seen this before?
Sorry, have I seen what?
Sorry. I'll go back to the paragraph. Sorry. Just give me 1 minute. The part that you showed in paragraph 22. Have you seen that document before?
No, I believe.
Before June this year?
No, I believe the first time I saw this was in this affidavit.
First time, you mean that's when Ms. Cesare provided to you for the production of the...
It's the first time I'd seen it, correct.
Okay, thank you. So then we go to paragraph 23. So that is a tax invoice, what you say. I've also provided below a screenshot of exhibits PA4 below. So is this also a document that's been provided by the VGSL?
I believe it was part of the affidavit.
And you do not think it's necessary to seek any approval from the parties who's produced the documents?
No, I do not.
Okay. Just give me 2 seconds. So can we go back to paragraph 15? So in paragraph 15 where you say, I have personally received several emails from the following email addresses. When you say personally, do you mean yourself?
They'd been addressed to me.
Yes. And was that also the case for Ms. Cesare or is just for you specifically?
I don't know whether they were also copied to Ms. Cesare. They were sent to me.
Okay. So in paragraph 19 Shas, so here you say, I've reviewed the affidavits of Mr. Ansell, where he described himself as a lawyer, and then you've exhibited a few of, well, there's a chart, listed affidavits filed in different proceedings. With BDD04A, that is a proceeding of a judicial review proceeding that's involving Mr. Kuksal, the parties, and the Legal Services Board. Is that correct?
That's correct.
And that's how you obtained the document.
Ah,
Because you were acting for
the party.
the party, yes. And the next one, BDD04B, affidavit of Mr. Peter Ansell filed in the Magistrates Court proceeding.
That's P73 of the PDF, we'll just bring that up. That's BDD04B.
So, a Magistrates Court proceeding in 11,679,381, dated the 8th of December 2023. Do you want to?
That seems to be a proceeding brought by someone called Lauren Reddy, V People's Shop Pty Lim.
Yes. So Mr. Davidson, do you know how did you obtain that affidavit?
I can't say, I'm afraid. I don't know.
You are not sure how you, or how that affidavit. How? Do you know if it has been provided by the Legal Services Board? Or do you know if you personally received it?
I don't know whether I personally received it. I think we were involved in this proceeding as a result of subpoenas that were issued. But I'm not aware precisely where this document came from.
Okay. You are not aware of you're not sure how this affidavit, how do I say? You're not sure how you obtained this?
No, I'm not. I'm not sure how the board became in possession of this document.
Okay, thank you. And that has been provided to you by Mrs. Siri?
Correct.
And she cannot be available for cross-examination?
She's overseas.
And the next exhibit is BDD04C. So, affidavit of Mr. Peter Ansell filed in the Magistrates Court, proceeding N11525466, dated the 31st of March 2023. Do you know what that proceeding is about?
I do not.
And how did you get possession of that affidavit of Mr. Ansell?
I don't know. Well, I'm sorry. It was provided by the board to us, but I don't know how it came into their possession.
So, do you have a firm knowledge that it was provided by the board?
No, it's an assumption.
Okay, and do you say the same for BDD04B?
Sorry. That was the Reedy document?
Yes?
I'm not sure about the Reedy document, because, as I say, I think we were involved in that by virtue of subpoenas. So, I don't know, is the answer.
Okay, thank you. Just give me 2 seconds. So just in contrast of the BDD05 with BDD06, you have a firm knowledge that it was provided by your client.
I'm sorry. You'll have to forgive me. Which document?
Oh, sorry. The paragraph 22, sorry?
Yes, I understand that came via the client from the VGSO.
Okay. Do you think it is a little bit confusing or misleading that you say that it's provided by the VGSO, or I have been provided an affidavit of Mr. Ansell by VGSO?
Well, it was intended to give the provenance of the document, where it came from.
Okay. Do you know, in what capacity did the VGSO give that document to your client?
I do not.
So when your client received that document, the specific document, your client did not tell you why and how and when the VGSO had given the Legal Services Board that document?
I have not had that discussion with the board, no.
And you were only being provided that document by Ms. Ciceri?
Correct. I was provided that document by Ms. Ciceri.
So, well, Your Honor, can I raise one issue? Is it okay?
Yes.
So I do have a bit of issue with the paragraph 22, because if you go to Ms. Ciceri's affidavit, she said the same thing. Let me open it.
Yes, she says, she has been provided an affidavit of Mr. Ansell by the Victorian Government Solicitor's Office. Trayed she tai kid in column force.
Yes, so I do take issues of that because I would say that it's confusing, or it's highly confusing that I would not know from either Mr. Davidson's affidavit or Ms. Ciceri's affidavit or Mr. Davidson's explanation or answers today regarding how that document is received. So in my reading, when I read this paragraph from Ms. Sisha, it's clear to me that she has received that document from the VGSO. And I had made a submission before, that is that the Legal Services Board's or the Legal Services Board solicitor's role in this proceeding is to provide legal advice or legal representation and so on to the Legal Services Board in relation to this proceeding. So I would say that it's unclear that, in what capacity if Ms. Ciceri has received the VGSO's document, then is she receiving it directly from the VGSO? And for what? For what purpose? So if, and we don't know this, it's that if there is a complaint made, then is it made to the board's lawyer, or is it to the board? So I would say that I object the production of that document.
All right. I should have made it clear. When I accepted the first affidavit, I expressly said that it was subject to your right to, or the defendant's rights, to argue over the admissibility of aspects of it. And I should make it clear that that was my intention, in the circumstances, with this affidavit, as well, in that I will reserve. You have the right to make submissions that I should not rely on that affidavit, if you want to, on the basis that there hasn't been proper evidence justifying how it was obtained, or the like. So I want you to understand that I'm not shutting you out from making that argument.
Okay.
Down the track.
Yes, so I just want to explain that the reason why I asked Mr. Davidson that question is to see if I can obtain evidence. So I will.
I think Mr. Davidson has made it clear that it was Ms. Cesare who received the document at cause, and he has received it as in his capacity as partner of cause, as when she received it, in that sense.
I read this affidavit, that she received it from the VGSO.
Well, I think.
So I will.
Well, I think.
And it's unknown.
And beyond that, there's no evidence.
Yeah, we don't know. We don't have Ms. Cesare's evidence here.
Yes.
About how she get it.
Yes.
Yep, okay. Can I just have 2 minutes?
Any re-examination at this stage, Mr. McAuliffe?
Yes, there would be.
That's all right. Yes, Ms. Xu.
So this is pretty much one of the last few questions. So paragraph 3, where you say, I make this affidavit from my own knowledge and based on my own inquiries. When you say that, those inquiries are solely from Ms. Cesare. Do you agree?
No.
And what other inquiries have you made?
Inquiries of several solicitors in the office, who have been dealing with this matter. Lee.
Okay. And when you say you are authorized by the LSB to make this affidavit, you mean that they give you instructions to produce those documents?
Correct.
Okay. That's fine, Your Honor. I do not have further questions.
Thank you, Ms. Go. Mr. McAuliffe.
Yes, Your Honor. I'm gonna have a difficulty with re-examination. I understand that, to the extent that the cross-examination challenges some of the authenticity or history of these documents, that can be answered through causes files that they hold. And we're just trying to make inquiries.
Well, I don't think it's challenging the authenticity of them. It's challenging putting you on notice that they might say that they can't be relied on.
Well, that might be so, but I understand that how they have come into Corus's possession can be answered.
Well,
we're just trying to make inquiries.
What are you proposing, though?
Well, I don't have those emails that show in my hands how Corus has received all of these documents. So, we're reviewing the files now, to try to be able to print those out.
To what end?
Well, to be able to re-examine with Mr. Davidson about how he has received these documents, particularly Exhibits 4A, 4B, 4C, and 5 and 6, as necessary. So,
for him to look at his file?
Yes, he has been asked, the cross-examination, in essence.
Yes, no, that's all right. So how long will it take for Mr. Davidson to look through his file?
Maybe 10 minutes, Your Honor.
All right. I'm anxious to finish Mr. Davidson today.
Me too, Your Honor, yes.
I will stand the matter down for 10 minutes, and Mr. Davidson can have a look at his file, and he can be asked to clarify.
Thank you, Your Honor.
Those aspects, if that's what you wish to do.
Yes.
5 to 4, please. Just recall Mr. Davidson, please.
Sorry, Your Honor. Can I just raise one question? So I was informed by Mr. Kuksal that he was. So he was escorted out, and the security guard was watching him and making sure he didn't come back in.
All right.
I want to ask what the court proposed in relation to.
Nothing at the moment. I'm just going to continue with the re-examination.
So, that...
We will deal with it later. Let's just finish with the re-examination now.
Okay.
Is Mr. Kuksal at court at the moment?
No, he was not allowed in, that's why I asked.
All right. We will proceed with the re-examination.
Mr. Davidson, while the court was adjourned, have you had an opportunity to review the files held by Cause in a number of proceedings in which it acts on behalf of the board?
I have.
So firstly, in relation to the affidavit of Ms. Cesare, which was affirmed on the 21st of June this year, have you reviewed the files held by Cause?
I have.
And from your review, are you able to tell the court when that affidavit was served on the defendants?
I believe it was served on the 21st of June 2024.
Thank you. Now, you were asked a number of questions in relation to a number of the documents referred to and exhibited in your affidavit, coming to them in turn. So this is Exhibit. Starting in order, Exhibit 4A. Have you reviewed the files held by Cause in relation to that proceeding?
I have.
And are you able to tell the court from who you exhibit 04A?
It was emailed directly to me by Ms. Zhu on the 17th of May, 2024.
And in relation to exhibit 4B, have you again reviewed the files by cause?
Yes.
And can you tell the court from whom you received it and when?
Ms. Zhu emailed it to me directly on the 8th of December 2023.
Sorry, which date?
Would you mind repeating that, please, Mr. Davidson? The date?
Sorry, it was Ms. Zhu directly on the 8th of December 2023.
And in reviewing your files, is it the case that cause was acting for the board as a subpoenaed party in the proceeding?
That's correct.
Coming to exhibit 4C, how did you receive this document and from whom?
The document was emailed by Mr. Kuksal to Ms. Cesare, and was then provided to me on the same day by Ms. Cesare, by email on the 31st of March, 2024.
Sorry, can you repeat? I didn't get it, sorry.
Yes. No, that's okay. Mr. Davidson, do you mind just keeping your voice up and just going a bit slower?
Sorry.
As to that date.
So, which?
Exhibit 4C.
4C.
It was emailed by Mr. Kuksal to Ms. CA, who emailed it then to me on the same day. All of that occurred on the 31st of March, 2024.
Just noting, however, that the affidavit of Mr. Ansel was sworn on 2023. Would it be the case that it was received by you on that date, 2023, and not 2024?
Oh, perhaps yes, sorry. Dud.
Now, and from your review of the files held by cause, in relation to the proceeding that's listed, or that's referred to in this affidavit, is it your understanding that cause is acting, or did act for the board as a subpoenaed party in the proceeding?
Correct.
Now, turning to, in order next, is Exhibit 5. Can you please, have you reviewed the files held by cause in relation to Exhibit 5?
I have.
And how did you receive this affidavit, and from whom?
Mr. Kuksal emailed this to me directly on the 26th of May, 2023.
And the board is a party to that proceeding?
Correct.
Coming to,
Sorry, which is this VDD 05?
apologies. And so the reference in Exhibit,
There's Kuksal versus James Mioch and others.
that's so.
That includes the board, does it?
It does, and I think in the case against Mr. Ansel that opened, there was reference to Justice Janin Nine's judgments in relation to that.
No, that's okay.
Yes, finally, Mr. Davidson, turning to Exhibit 6. You reviewed the files held by cause in relation to this matter?
I have.
Sorry, in relation to this exhibit, I should say.
I have.
And can you please tell the court how and when you received this document, this exhibit?
This document was delivered on the 6th of October 2023. It came from the VGSO to Mr. John Lizaris, who emailed it on the same day to myself and Ms. Cesare.
Can you repeat?
Who is Mr. John Mazaris?
Correct.
Who is he?
Sorry, he's an employee of the Legal Services Board.
Can I ask to repeat it?
So the 6th of October 2023, it went from the VGSO to the Legal Services Board and then to cause.
Correct.
And it was received by you directly from your client to the board on that date?
Correct.
Pardon me one moment, Your Honor.
Sorry, can I have the witness repeat, as I just haven't made the note?
Mr. Davidson, if you don't mind just repeating your answer if possible, please?
The document was provided on the 6th of October 2023. It was provided by the VGSO to Mr. John Lizaris. And then John Lizaris provided it to myself and Ms. Cesare.
On the same date?
On the same date.
And Mr. John Lizaris, as you said, is an employee of the Legal Services Board and Commissioner?
He is.
No further questions arising for re-examination.
Thank you. Thank you, Mr. Davidson. You are excused.
Thank you.
That now leaves the question of the notice to admit.
It does, Your Honor.
As I understand it, there's no issue that they were served and there's no notice of dispute filed, but Mr. Kuksal at least has indicated to me that he wishes to contend that the notice of dispute process does not apply on the grounds that this is a criminal proceeding. I've ordered him, the defendants, to provide submissions to that effect some days ago, and nothing has been provided. What do you say? Should I receive them subject to them making further argument in relation to that?
Yes, Your Honor, I don't have an issue if that's the case. I think Your Honor should receive them, and Your Honor should receive them subject to further argument. I am not going to oppose a further opportunity being given to them.
Well, Ms. Zhu or Mr. Ansel, I will ask first.
Yes, Your Honor.
With the notices to admit, I think you've made it clear that was served and wasn't responded to, but Mr. Kuksal at least, and you may have adopted his argument, want to say that the whole notice to admit process should not apply in this proceeding.
Yes, that's correct, Your Honor.
You were ordered to put in a written submission in relation to this some days ago and it hasn't been done. One option would be to say it's too late, the notices to admit are going to bite. but probably it would be in the interests of justice to, given that I'm going to be directing written submissions in this matter in any event, and those submissions are going to direct admissibility issues in relation to the affidavit material, that I should also require that those submissions deal with the issue as to whether the notices to admit should take effect. Are you content with me proceeding on that basis, or do you want to argue it?
Yes, Your Honor,
Rather than arguing that now.
we would be in a position to file submissions
Yes.
in relation to that point.
Ms. Shu, have you got anything to add?
I would prefer to deal with it in oral submissions. I don't take too much time, I think.
All right. Off you go then. But either.
Your Honor, can I just raise one issue
Yes.
just before Ms. Yu starts, given the situation that arose this morning, just for the record,
Yes.
if it's required, I would like to make some clarification in respect of the applications that were being made by Mr. Kuksal this morning, just to point out that both Ms. Chu and I.
Give me a minute. Ms. Shu, I think on reflection, it does make sense for me, given that Mr. Kuksal, possibly, and Mr. Ansel, are going to be making submissions in relation to the notices to admit in writing. I think I will direct that all parties make those submissions in writing, rather than hear an oral submission from you, and then a written submission from others later.
But how are we proceeding to?
Well, what I was going to do was I'm going to say, I will. My provisional view, not having heard argument, is that the notices to admit do take effect, but I am conscious that I haven't heard a developed argument by you, the defendants, on that point yet. So I will require that that point be determined, be addressed in the written submissions on the matter, that is.
But,
So you will have to deal, in your written submissions, with alternatives. One is the alternatives, that the notice to admits do take effect. What you say I should do if I think the notices to admit do take effect, and the evidence is, in the affidavits, is admitted. And what you should do in the event that I don't accept the evidence to which you object, and don't accept the notices to admit as being effective.
Can I object to that?
Why?
I have some difficulties in writing, I think. I think it will be easier.
What are you proposing?
Is it possible that I can make submissions about that? But it won't.
How long will it take? And?
10 minutes, 15 minutes.
You want to make your submissions? You want to make your submissions on the notices to admit now? Orally?
I want to do it either. It will be good that, if I can do it tomorrow.
No, we're not going to come back tomorrow just for a 10-minute argument on that. The way I'm thinking at the moment.
But are we not?
No, I think.
Scheduled for 3 days?
Yes, we are. But I think the evidence is finished now, so. Anyway.
Your Honor, can I just raise a possibility?
Yes.
If Ms. Zhu makes oral submissions now for 10 or 15 minutes.
No, but she's not saying 10 minutes now. She's saying she wants to. It will take 10 minutes to present them, but she wants to do them tomorrow.
I did hear that, but if she is able to present them now, I wouldn't object to her having a further opportunity, in written submissions, to add anything further.
All right. Okay, that might be all right. I'm coming back to you in a moment, Mr. Ansel. I'm conscious that you haven't finished what you wanted to say.
Thank you, Your Honor. Thank you, Your Honor.
Miss Kaur, that's the evidence. The evidence is at its end in this matter, and I'm going to require written submissions. I think the parties are going to be better off spending tomorrow on their written submissions than on anything else. So, I will offer you if you want to speak for 10 minutes about the notices to admit now, I will let you do so. But I will say, you can also address it in a written submission. All right. Now, do you want to do that, or do you want to just wait and put it in a written submission?
I will take 10 minutes, and then also, if anything to add, I will
All right.
do that in writing. But I want to understand the schedule, if that's
Okay. All right.
possible. And if I can just advise the court that I understand that Mr. Kuksal is bailed to Melbourne Magistrates Court on the 26th of August. That was scheduled in May, in May, the 26th of August.
All right.
So I just want to. Yep.
I work on the basis that all the arguments that the defendants wanted to present orally are arguments that they have prepared in a proper matter, so that it should not be a time-consuming exercise to reduce them to writing. So I'm going to have a reasonably prompt set of directions. I have already made an order that any recusal applications be made by writing, filed and served by the 22nd, that is, tomorrow, at midday, all right? That.
Can I please request it to be midnight?
No.
Midnight?
No noon tomorrow. You all came along, intending to make a recusal application on the moment this case started. The recusal application should have been, if it was going to be prosecuted on that occasion, then it should have been ready to go. So it can be done in writing, as I ordered at the time,
Can I just respond quickly?
by noon on the 22nd of August 2024.
But can I please respond to that quickly?
No, I've made that order already.
Okay.
Okay?
Yeah.
I made that some days ago. And I will indicate that if something doesn't come in, I will treat it as not being pursued, or dismiss it. And then I will have to make directions for submissions otherwise. And those submissions are going to have to address any objections to the evidence, and any objections to the notice to admit, and the submissions on the merits of the matter, so to speak.
Court pleases. Yes.
Yes. So that will take a little bit of time, just because life is difficult, and there is a number of matters there.
Thank you, Your Honor.
What I am inclined to do at this stage, unless somebody wants to try to persuade me out of it, is to order an exchange of submissions by a certain date, and then an exchange of any reply submissions by a certain date, rather than have one then the other then the other. Are the parties content with that?
Sorry, Your Honor. I didn't.
Well, instead of one party putting in a submission, and because everybody has got, you're running your objections and so forth.
Okay, yep.
I just have a date at which both parties exchange submissions by a date, and then another date where parties exchange any submissions in reply. Today is the 21st. You've all got Monday. I was thinking of having those submissions in, well, you tell me, what do the parties think? I was hoping to get them in this week, the initial set of submissions in, by 4 p.m. on Friday. But if that's unrealistic,
I think, just given the nature of this, and
yes.
the objections, it might be somewhat unrealistic.
All right.
And
Well, maybe I will give till 4 p.m. on Tuesday, the 27th.
if the court pleases,
4 p.m. on Tuesday, the 27th for those submissions, and any submissions in reply by 4 p.m. on the 29th. 2 days. Is that enough?
yes, Your Honor.
Look, maybe in the circumstances, I will make the first set of submissions by Wednesday, the 28th. I'm sorry to change my mind, by Wednesday the 28th, and then submissions in reply by 4 p.m. on Friday the 30th.
As the court pleases.
Now, Mr. Kuksal, Mr. Ansel, I want to clarify this aspect with you, Mr. McAuliffe, in a moment. The allegation against Mr. Ansel hinges, to a considerable extent, on the, as I understand it, and subject to things being admissible, on the bill of costs that was sent.
Yes.
In which Peopleshop asserted, it would seem, an entitlement to be paid.
Yes.
Is that also put against Mr. Kuksal in a sense that it is said that Mr. Kuksal must have been aware the Peopleshop was asserting to be charging costs to him?
Yes.
All right.
And the metadata would also in my submission give rise to that inference as well.
All right. But that doesn't bite against Ms. Shu, does it?
No.
So what really is the case against Ms. Gu? Is it just the production, by her, of documents that have Peopleshop Pty Limited between the tram lines?
The sending of emails, yes, and the production of those documents. As well as I would call it.
All right. No, I'm not holding you to this. My initial reading of the matter made me think that, although the bill of costs potentially is something that Mr. Ansel and Mr. Kuksal might be caught up in, I couldn't see it having anything to do with Miss Dull and Amichu.
Not on its face, no. As I put in the final sections of the opening submissions, there is a real issue with Ms. View as company secretary and officer.
Yes, and officer. That's true. All right. Fine.
And there's just some concerns. And can I, just before we rise, Your Honor, and I'm really aware of the time, I do note that Your Honor asked me, I think it was yesterday at this point, just about the form of S11, as to subparagraphs 1 and 2.
Yes. Agents and the like.
Yes, and I do apologize to the defendants in the court. I might have been too hasty in reacting to that. It might be, particularly depending on how the argument closes in terms of some of the metadata and some of the issues in cross-examination, that alliance is placed as well on 1 and 2, and it was never particularized to be either or in the opening submissions.
When you say 1 or 2, what do you...
Apologies. Subsections 1, or subs 2.
Of section.
Section 11.
All right. That's all right. Now, with the metadata, how is that proceeding? Alti fiats.
We can do that.
How is it before the court?
It is before the court in the electronic version of Ms. Cessary's affidavit.
So do you need the exhibit to Ms. Cessary's affidavit to be...
I can have an electronic form of Mr. Davidson's affidavit put before the court,
Yes, well do that please. So his affidavit is a
wet ink. Yes.
document has the metadata, but the copy that's been provided is the paper copy only, without the metadata.
That's so, yes.
Alright. So it's a matter of an electronic copy, a proper electronic copy, of his affidavit being circulated.
That's so, Your Honor.
Alright. And the exhibit will be an electronic copy then,
Yes, I would seek to lead that.
which included the metadata.
Yes.
Alright. Done. Now, Mr. Ansell, you were saying something. Alright.
Thank you, Your Honor. As I was indicating to you earlier, just for the record, I just wanted to make some clarity in respect of the proceedings earlier today, in that Mr. Kuksal had made a number of applications.
Tell me which application you're referring to.
Right, well, it was applications in regards to credibility of Mr. Anstee. He was...
I ruled on that yesterday.
Yes, Your Honor. I just wanted to say that in regards to, I don't think he was trying to make an application for recusal. I know that Your Honor then said you'd ruled on it in respect of that.
The situation with the recusal I think is beyond any confusion. I've made it clear, I was just not going to permit him to present a recusal application other than in writing, on or before 12 o'clock tomorrow.
Yes, Your Honor, I understand that. I just wanted to clarify that both Ms. Hesho and I were in agreement that he was trying to make that application. I just make the...
Look, just if there's any doubt, I don't think there is, but I'll state it now. I accept that the defendants were seeking to make a recusal application, orally, immediately, without notice, etc. And I have said I wasn't prepared to hear it immediately, and I required any recusal application to be made in writing by 12 o'clock tomorrow.
Thank you for clarifying.
If I'm wrong to have done that, I'm wrong to have done that.
Yes, thank you for clarifying that, Your Honor.
There's no escaping that's what I did.
Yes, I didn't want the court to think that we were waiving our rights in respect of that matter. But I understand what Your Honor has said.
Thank you.
Thank you, Your Honor.
And in terms of the other, I made a ruling that the cross-examination that Mr. Anstee, I made the ruling late yesterday.
Yes, Your Honor.
What I required. I
suppose the only issue there, Your Honor, is whether those rulings should have been made before the recusal application.
Yes, I understand that argument, that's something I have to indistinct. But what happened is, I made the ruling, and I said I wouldn't hear the recusal application.
Yes.
So, as I said before, that's either right or wrong.
Yes? Sorry I missed that last.
That's either right or wrong.
Yes.
What I did is, I know that Mr. Kuksal at least, and possibly you and Miss Shu, thinks that I'm falling into error in my approach to those things. But I confirm that that is the approach I have taken, so that somebody else maybe one day can evaluate the rightness or wrongness of that.
Thank you for clarifying your position, Your Honor.
Thank you, Mr. Ansell. Miss C, do you want 10 minutes to explain why the notices to admit should not take effect?
Yes.
All right.
Yes, so I have mentioned last time, briefly, about why the notice to omit is a contravention of the Charter.
Contravention of the
Charter. And that's when I was making submissions about the Charter notice should be taken into consideration before the court commences. Theory.
So your argument isn't that it's a criminal proceeding, it's your argument that the notice to omit process is contrary to the Charter.
It does, yes. Because the Charter says that in a criminal proceeding, not in a civil proceeding.
Okay.
The Charter says that you have privilege against self-incrimination.
Alright, I understand. So I thought you were putting a different argument, but this is under the heading if you like. The argument that this is a criminal proceeding.
Yes, I said that it has that implications.
Yes.
Yes. And then the Charter says that in the criminal proceeding, or in that sense that you have privilege against self-incrimination, then you shouldn't be enforced to admit by way of the operation of the notice to admit.
Yes. The thing that I'm intrigued about is about why it is said that this is a criminal proceeding.
Sorry? So, because the way the Legal Service Board's submission was put, was that, so first of all, S4473 says that, you have committed an offense, you are committing offense, or you are likely to commit an offense.
Contravene to section.
Yes, contravene to sections of the Uniform Law. And in my circumstance, or in the other defendant's circumstance, when they chose S10 and S11, then that's made it a criminal provision. So those are contravention that can be.
So it's as simple as the fact. The argument is as simple as being that because somebody can be charged with a contravention of those acts, those provisions of the Uniform Law, that is, the Uniform Law provide penalties for them being breached, that is sufficient to make this a criminal proceed as an argument. Those act.
The argument is how Mr. McAuliffe had said in his submission is that, so you can, there are three options that they can have. It's, I have committed an offense, or I am committing an offense now, or I am likely to commit that offense.
Yes.
They have chosen the first one, which is that they have said that I have committed the offense.
Yes.
They are not saying that I am doing that right now, or I am likely to do it in the future.
Yes, I see.
The option that they chose is that I have committed an offense.
Yes.
So I would say that the court has to, in order to accept their submissions, and take their approach, the court obviously have to, first,
Make a finding on the
make a finding.
balance of probabilities that you committed an offense.
First have to make a finding that I have committed that offense, because that is the approach that they have taken. They can say that I am likely to commit an offense, or I am doing that right now, but they didn't say that. It's confirmed in Mr. McAuliffe's submissions, that's what he said. So, in order for Your Honor to accept their claim, or their claims for relief, first step will be that Your Honor will confirm that I have committed
I understand that, yes.
an offense. So, that's what I say it has, why I say it has a
All right.
criminal implications.
What I want you to reflect on, Ms. Sue, is this. I know that the occupational health and safety legislation provides regulations that apply to employers, as to steps they have to take to look after the safety of their employees. And if they breach those regulations, they can be charged and found guilty of breaching the regulations, and they can be fined. Every day, workers bring actions in negligence against their employer, and they rely, in their negligence action, on the fact that the employer has breached the occupational health and safety regulations. That is, a breach of the regulations can be relevant to the issue of whether they have acted negligently. I have never heard anybody suggest that, in an action like that, based on a breach of a regulation, the criminal procedures have to apply. So what you're saying,
I can answer
strikes me as quite
that question now.
a novel argument.
I can answer that question now. It is that is because the Legal Services Board had already designed, or they have already worked out the routine in their legal submissions, is that they said that I have contravened S11.
Yes.
That is why, that's based on S447(3) of the Uniform Law.
Yes.
That the court should impose a permanent injunction against me, in order for Your Honor to
Yes.
apply that section subs 3, of the 447. You have to accept their submission, or their assertion, or
Yes.
allegation that S11 is contravened by me.
Yes.
And S11 and S10 happens to be criminal provisions.
No, I understand that argument.
It's because of how they have,
And do you have any cases that say that a regulatory authority who is seeking injunctive relief, or something like this, that the proceeding is, are you arguing from first principles, so to speak? Or do you have cases that say, where it has been found by other judges, that a case such as this is criminal?
So, Your Honor, I can do some research, but the point I make, I think Your Honor already understand, is that they said that I have.
Yes, so because they
have committed a criminal offense, they said I have. That's why, after the court found that I have committed a criminal offense, then I should be getting an injunction against me. So that is
Yes.
what they said.
All right.
The steps are, there are a few dots.
No, I understand that point. You're aware that, if the notice to admit process does apply, the admissions are only admissions in this proceeding. They can't be used in any criminal proceeding?
Yes.
Yes.
But what I'm saying is that the findings itself will be an implication of criminal acts.
No, because isn't the argument against that a criminal case has to be proved to a different standard, and so the fact that a court might find on the balance of probabilities that you've contravened a section of the Act does not mean that you are necessarily guilty of the criminal offense, or
But then my first argument will be that that will be an abusive process. They should have tried the criminal thing first.
Yes.
And then the second thing is, they've given me the notice to admit first. Then after a week and more than a week, 10 days, they revealed that they are using S11. I have completely no knowledge, no warning.
Okay.
Absolutely don't know how they are going with that case.
All right.
So my argument is that this caused tremendous prejudice against me. They cannot serve you a notice to admit, in a civil proceeding, first, and then say, surprise, I'm gonna,
Well,
implicate you in a criminal
that would have some
case.
That argument would have more weight, wouldn't it?
So,
If
that they've done that first, is what I'm saying, is why I do.
Well, Why didn't you just, if you dispute the facts in the notices to admit, why didn't you just dispute them?
I'm not saying you would.
Anyway,
You mean?
you don't have to answer that.
No, I mean,
It's perhaps beside the point. Look, I understand your point, Ms. Xu, and I will expect the point to be fleshed out in the written submissions. Yes. It's a live point. I understand that. I am going to have to decide whether this is a criminal or a civil proceeding.
okay, and, yep, but then, what? Where do we go from here?
Well, you do your written submissions. And when I've read the written submissions, unless I call the parties together and say I want to hear further oral argument, I will put out a set of reasons in due course. And those reasons will deal with what evidence is admissible or isn't admissible, what happens to the notice to admit, and whether the board have proved their case.
But I do not consent to, either, that the trial is conducted in by way of written submissions. Also, you haven't asked Mr. Kuksal if he wants to make.
I'm directing written submissions, Ms. Xu.
But how can we just do written submissions without
Without me having first made rulings on matters?
a hearing?
Well, there's one issue that concerns me. I did turn my mind to whether it's fair to ask the parties to write written submissions without me having first made rulings on the evidentiary matters. And I have formed the view that it is fair for me to do that. And so the submissions will have to deal with the different eventualities. Like you will say, this is what we say is the proper result of the evidentiary issues, and this is what the result should be. But if we're wrong about the evidentiary issues, this is what we say the result should be, and why.
But
That's the way I've decided to
no, but
do it, Ms. Xu, because,
I didn't know that until just now, so,
well,
can I just say that would not be fair, because there is a possibility that first, then, it will be not enough time for the timetable that has been set out.
I disagree, Ms. Xu. You are ready to run these arguments now, aren't you?
No, I haven't heard how, after the cross-examination is done, then how Mr. McAuliffe will argue the case, and if we have a hearing, then I can clarify things with counsel. If not, then
Would you rather, instead of exchanging submissions, would you rather have submissions from the board first, and then you respond to them?
I think that would be much.
But the problem with that is that
Well, no, it's not
the board,
going to be enough time.
the board hasn't then heard your arguments on the evidence. No, I think I'll stick with the directions I have made.
Well, then I will say that's enough time. If we wouldn't be able to get a hearing for
All right.
I think it's quite unusual that the court would, after hearing the evidence, order that.
What I might do is, in the circumstances, I'll require the first set of submissions to be exchanged by Wednesday the 28th, as I ordered before. But I'll say that the reply submissions, I'll push them back to the next Wednesday. So I can see what your point, Miss Yu, is, that there might be stuff in the submissions you get that you haven't properly anticipated potentially. So I will order the parties to exchange submissions by 4 p.m. on Wednesday the 28th, and then I'll have any submissions in reply by 4 p.m. on Wednesday the 4th of September.
But we haven't heard Mr. Kuksal's submissions about this approach.
Well, Mr. Kuksal, in my view, has decided not to participate in the case.
Well, he said he was prevented from, and
I told him he had to leave, and I said there was a room available for him to observe the proceedings, and he told me he wasn't going to take
well, you said observe.
advantage of that, and he was going to leave, and he asked you where the car was, and you gave him a set of keys, and he left the building. That's what I saw. We'll adjourn the court.
Sorry, Your Honor.
Your Honor, can I just request that reasons be given? I have raised my objections against that, not having a hearing for the final.
Oral argument?
Yes.
No, I haven't yet decided whether I will. When I get the written submissions, I will form a view on whether I want to proceed on the papers, or to proceed by way of, or call the parties in for an oral argument.
I raise objections. I just want that to be recorded, and if.
Okay, that's recorded. You want some reasons?
Yes.
My reasons are that I consider in this case it's going to be,
And can I say it's difficult?
for a number of reasons.
It's difficult for me to.
First, in the circumstances, I think it's appropriate and reasonable to require parties to present their arguments in writing when they're literate parties who purport to be in a position to present their arguments orally already. That is, it's a matter of reducing into writing the submissions that they have prepared. Secondly, the danger I perceive if the matter proceeds orally without written submissions is that parties are caught by surprise by their submissions that are put, and are then not in a position to respond, and it leads to further delays and further costs, which I am keen to avoid if at all possible. And thirdly, if I'm up 3, I consider it a reasonable way of determining a matter to have it determined on written submissions. That is not to say, monsieur, that when I look at it, I might not think that it's appropriate to call the parties back to have further argument. But you should not assume that you're going to have the opportunity to have a further argument.
But I do oppose.
Okay, you oppose it, that's okay. But that's what I have decided. So you can't, whatever arguments you want me to have regard to, you've got to put in your written submissions.
Okay? Alright, so I understand that's the position, and if I can just request the court to give reasons and record my objections.
You have had your reasons.
Okay,